My Lordship, serial number 28, a short accommodation may be granted, my Lordship, due to personal inconvenience to the senior, not able to be present on video call as well as personally. Physically is not able to be present here as well as on the video call, my Lordship. A short accommodation may be granted. Serial number 28.
This matter on 22nd at the request of Lords for the petitioner. Yes.
My lords, serial number 14, my lords.
Yes,
Respondent advocate is not in station. I appear for the council, seek for a week's time in this matter. Actually,
I think on the last occasion, I think also he was not present.
that I'm not aware, my lords.
But we will see. He can't on the last occasion, he can't, that's why the matter is posted for further hearing. We'll see.
It was
how
supposed to
and
be listed on 10th. That is what my instruction was. It was agreed that it will.
We will see what is the, how it has come today. Yes, next.
My lord, serial number 8, my lord.
8.
For respond number 1 to 3, my lord. Today you have filed a wakalat, my lord. 1 week timing.
Was this matter on 22nd at the request of Learned Counsel, the respondent, stating that today they have instructions to file wakalat and today they are going to file.
Wakalat filed.
They have already filed the wakalat. Yes, next.
For the petitioner, my lord. Respondent number 14 notice await is there.
Awaiting service of
Yeah, kindly grant one specific.
R14. What has happened? See,
Fine.
when was the notice sent?
Last occasion.
1 minute.
Yeah.
Let us.
Process paid on 26/6.
When you have paid said process?
26/6. Last month.
It doesn't reflect. The office note. Why? They are saying await notice. There must have been some date must have sent. When? 1/7. Was this matter?
Grateful, with your kind permission, man. I posted, I made a mention on the last date of hearing.
Oh.
Say, seeking an urgency in this matter, man. This suit is of the year 2000, man. This is a partition suit which has been decreed in the year
Partition.
2017.
But without a notice, how can we hear the matter?
All of them have been served, my lord. In fact, when the this honorable court,
R14 need not be heard.
no, this honorable court, my lord, when the interim order was granted, there was a direction to the petitioner to serve the copy on the counsels representing the.
Did
In
you do so?
FDP.
That's been done, my lord. That's been done, and
Is it done? Let's see. So look at the, please do those proceedings. When did you file a memo to that effect that you have served?
26/6. Court notice not served.
Huh?
R14. Court notice not served.
Not served. You are permitted to take out notice.
Please.
You have taken out.
Yeah, sir.
Then where is that memo to that effect?
Memo dated 26/6/2014. I filed it.
26/6/2014. Let's see.
Before.
Where do you get the date?
The ton.
3/3/2023.
yeah, 20.
This court on 9/2/2023 has permitted the petitioner to serve notice on the counsel appearing for the respondent number 14 before the court below, and the notice is served. And he has also filed a memo to that effect. on 26/6/2024. The notice was served on 3/3/2023
23.
and a memo is filed on 26/6/2024. Notice to the 14th respondent is held sufficient. Yes,
This
what is
urgent-
the petition about?
My lord, the suit is of the nature of partition, my lord.
Hmm.
The suit was filed in the year 2000.
Hmm.
2017 April, my lord, the suit gets decreed. This is a preliminary decree which has been passed by the learned trial court, my lord, which has been challenged before this honorable court by way of writ petition.
Decree is challenged.
Decree is challenged, my lord. Kindly see the prayer, my lord. Kindly see the prayer.
There is an interim order in this.
R1 to R10.
There is an interim order in this.
Yes,
There's an interim order passed, my lord. There's an interim order passed on the FDP proceeding, final decree proceedings, and the final decree proceedings have been stalled. The urgency is this, my lord. The suit scheduled property is a.
So first of all, on the
Please.
maintainability.
Yes, my lord,
how
it's
can
not
it be the
maintainable.
Judgment and decree a petition at 227 is
Please, my lord,
maintainable?
this honorable court may kindly note that the petition is not itself maintainable, my lord. In fact, they had to file an appeal under section 96. But, my lord, even probably, my lord, to avoid the terms of the delay, they filed this
By which order the stay was granted by this court?
order dated
stayed in FDP proceedings. Sir.
That's what. where
9
is
to
it?
2023, my lord.
Huh?
9th February 2023. In fact, when the interim order was also granted, the learned judge also noted that, on the maintainability, it still kept open.
Let's see the order.
It is pointed out by the learned counsel for.
Are you questioning the judgment and decree?
Yeah, please.
How a writ petition is maintainable against that?
As
First
per
you have to-
as per the Supreme Court judgment,
What is the judgment?
we will quote a judgment,
Let's see.
Danappa versus Amar, madam, which is passed in there too.
equal share, equal share.
It is not about equal share. How can you file a revision? It's a revision, though you have filed a writ petition under 227. How a judgment and decree is a revisable order?
Kindly grant one specific.
What one, first of all,
Senior-
pending
senior-
this writ petition from 2021 itself is it's an abuse of process. Now, where will you go? You have to question the judgment and decree by filing a regular appeal. Now, if the court do not grant you a liberty, what will happen? Because this writ petition is not admitted so far.
Kindly grant one specific.
No, 1 week, a maximum
Alla,
Passover.
At least tomorrow.
No. Passover.
Great.
Yes, next.
Petition. Lord, I have already taken steps to quote my lord on 22/6. And the service on the advocate, my lord, is refused, my lord. To that effect, I filed a memo, my lord. My lord, the respondent, my lord,
This
intentionally.
court on 21/6/2024 has permitted the petitioner to take out the notice on the council appearing before appearing with the respondent before the court below. And as per the order, the land council submits that as per the order of this court, he has served the notice on the council and has also filed a memo dated 5/7/2024. What is the advocate's name?
And advocate name is Ram Krishna, my lord. Affidavit is also filed.
Where is that?
Filed on 5/7, affidavit Ram Krishna, my lord.
An affidavit to that effect is filed that the notice is, the petitioner advocate went to the office of the lawyer Sri Ramakrishna. But it is, he has refused it.
He has refused, my lord.
Huh.
Notice through court I have already taken, that is still in process, but notice on the advocate is refused, my lord. To that effect, I filed a memo.
The council has refused notice. When was the notice taken?
Uh,
When
Through
when
court,
was the notice sent?
through court, my lord,
To court, when was it sent?
22/6, my lord. I have taken steps on 22/6, 2024.
Any interim order is granted in this?
No, my lord, that's the reason.
What is the writ
But
petition?
the 6,000 rupees is the maintenance order, my
Hmm.
lord. Now the wife, my lord, is already married to the other person, Parthasati. Wedding card is placed on record, my lord.
Let
Photographs
counsel
are
for the
placed.
petitioner submits that though the respondent is married, married, she files a present petition seeking maintenance, and the same is not, she is not entitled for any maintenance. This particular aspect was not considered by the trial court. Hence, there shall be stay of all further proceedings pursuant to the order passed in so and so, till the next date of hearing, post after service of notice. Yes, not necessary because he refused the notice. Yes, next.
For the I undertake to file wakalat for respondent, my lords. Respondent is resident of Mumbai. Last week, my learned friend served the notice, my lords. Next date, and also matter pertaining to before the trial court referred to settlement. Settlement, my lords, this month end. Kindly have it next month, first week, my lords. I will file in meanwhile, I will file wakalat also for it.
When was it referred for settlement recently?
Last week only, my lords. Last week referred 24th.
Counsel for the petition as well as the counsel for the respondent submits that the court below, the trial court had referred the matter for mediation, post this matter on 29th. Yes, next.
I appeal to the petitioner, my lord. Senior counsel's on his legs, kindly pass over.
Pass over. Yes.
Petition for petitioner. In this case, I have filed 4 IAs before the trial court, which has been rejected. One is for the summoning the one Ajit Kumar, who is a neighbor, who has signed the document of my son's health issue. And another document is she has claimed that I have not paid any single pie. I have sought this hospital authority to produce the document. Third one is she claims that I have not paid a single fees to my son. That I have paid it. That I have sought summoned. Another fourth IA is with respect
Now,
to
what is the third IA?
third IA is summoning the school documents, which fees. She claims that I have respondent. I have not paid a single fee. Fourth IA is with respect to, because she is a questionable character. She travels around the globe. She gone to Singapore and stay there. I sought through the Advocate General of India to the counterpart of Singapore to furnish Form 14 details. And I have sought for staying up the trial court proceedings also.
Why you wanted the trial court proceedings to be stalled?
Any date may be fixed after serving till this.
No. You are submitting before this court about these IAs.
Yes.
What happened to those IAs?
That has been rejected by the court.
That we will see the order first.
Yes, kindly see the page. Order sheet 128 to 132. 128 to 132.
1 minute.
Should be copy of the order 133 to 140. 133 to 140.
So it's MC of 2013,
Yes.
filed
That
by
is
whom? 2013 MC filed by whom?
by petitioner.
That is husband,
Yes.
seeking divorce.
Yes.
Then
And,
MC number
see-
6164,
She filed in 2017.
seeking?
Seeking again the same divorce. We sought divorce from the grown-up desert.
Please come to the order at page 134.
130. The court has given the reason that just because of delaying tactics, they have filed this application. That
Let's
is
see,
what.
let's see.
Yes.
No, you find these IAs for what purpose?
For summoning those dogs.
No, purpose.
Purpose is to prove the cruelty, the laying of, lying, always he lies that I have not done, this I have not done, that one.
No,
And for the adultery.
no, you want divorce.
Yeah,
You
I want
divorce on the
divorce, yes.
ground of cruelty and some other ground, adultery and some other grounds.
Yes,
She wanted divorce on the ground of
Ye-
cruelty.
yes.
No, or whatever that you wanted to prove,
Yeah.
how it is necessary to prove the adultery?
I have taken the contention that she is practicing this adultery with so many things.
Correct.
And I have cross-examined
These
also.
IAs, how are relevant for
The
this?
Supreme Court has held that though adultery is legalized, the parties can seek divorce on that adultery.
No, court is not, it is correct.
Huh.
What the court is saying is,
Huh.
no, the 4 IAs which you have filed,
Yes.
how are they helpful to
Huh.
prove your case
Huh.
Seeking divorce
Huh.
on the ground of adultery?
Yes, it helps.
How?
Which have sought when she gone to Singapore and stayed with a man who is a relative of the petitioner.
Where is your IA? Let us see. IA, affidavit.
Ah.
Where did you say all this?
IA 21.
Yes.
Okay. IA 21, page 113.
113.
Another, before that, I want to bring to this court, trial court has allowed my applications. Firstly, all 4 IAs has been allowed. And later, after 2 days, the court directed the respondent to file review petitions. Then this order was passed. It's forthcoming in the order sheet.
No,
Okay?
before that, let us see
Aye.
the affidavit.
Affidavit.
Yes.
One 113 page number.
Yes, please come to that. Which IA is this?
IA number 21.
Where are the other IAs?
Other is 18 to 21, 18 first IA. Page number. Annexure. Annexure. G. Annexure, G, E first. Annexure E,
Page number.
page number 79 to 83.
So what are these IA number 21?
21 with respect to the Singapore.
Then summoning one Ajit Kumar, that is IA number.
IA number 18.
Then to produce, what about the details of the school?
that is 20. The 20, IA number 20.
IA number 19 is?
19 is summoning of the hospital records, where my son gone operation for the urine loss.
For all this, all the 4 IAs, this writ petition.
Yes,
Please come. Agreed with the order passed in. I number 18, 19, 20, 21. Dated. What is the date of order?
date of order.
Dated
3rd January 2024.
3/1/2024. The petitioner husband is before this court. Then counsel submits that the petitioner has filed a MC seeking divorce on the ground of adultery. The wife had filed he filed it in the year 2013, and wife had filed the petition for divorce in the year 2017, seeking divorce on the ground of cruelty. The IA number 18 is filed to summon one Ajit Kumar, and IA number 19 is filed to produce the hospital records. And one more thing is, you have not filed any application to reopen the evidence when your evidence is closed.
That one kindly see the page number. Or we see, 133 to 140. 133 to 140.
Yes,
Wherein
court observes in that order that you have not filed.
in page number 128. Page number, the same in the order sheet, page number next, wherein it is said that heard on IA number 18 to 21, as the counsel for the petitioner intend to examine the weakness and also to summon the document in the application are hereby allowed on the cost of ₹500 each by overruling the objection filed by the respondent, as party is entitled to produce all evidence available to him to prove his case. Antare. He has the order is possible. In the next, he asked, orally asked the other side to file a review publication that I will allow it.
Then this order should have been passed in the review IA. Review, in the review IA, the order should have been passed.
Yes,
No, which is IA now? IA 18 to 21 only, it is passed.
yes,
Where is the review petition?
that I have not filed.
Ah, Please come, just discard all that. Then council submits that by order dated 17 to 2023. The court had allowed the IS number 18 to 21 on cost of ₹500 each. Then council submits that court has orally asked the council to file a review and pass the present order rejecting all the applications. Wherein the court below had observed that the present petition is filed to drag on the proceedings, and also the, after the evidence of the petition is completed, without asking for the reopening of for reopening his evidence, had filed these applications. And on that ground also, they are not maintainable. This court had perused the docket, the order, as well as order dated 17/2/2023, and the present order impugned. This order is passed on IA number 18/21. How come the court had passed these orders, having already allowed the IA earlier? Even to think that this is a review order, but the order reveals that it is not on a review file review. The learned judge, the first additional principal judge, Family Court, Bangalore, shall submit a report to this court. Why, after allowing an order on 24/2/2023, why an order, and again on the very same IAS, why an order is passed dated 3rd January 2024? The report shall be placed before this court within 1 week from today. There shall be stay of all further proceedings in MC number so and so, so and so. There are 2 MC. Yes. Post this matter next week. Post this on 24th, not 24th, on 18th. Yes. A notice. Petition is permitted to take out notice on the counsel appearing before the court below for the respondents and file a memo to that effect by next week.
Oh.
Yes. Yes.
Your office, petitioner husband,
Hmm.
it is a 125 proceedings,
How much is granted?
6,000 granted actually.
Huh?
6,000. I am an coolie actually, working in a village. I am ready to deposit 42,000, 50% of the total award.
No,
6,000 they have awarded. I am in coolie in the village actually.
daughter is, child is also there.
Child is not, only wife.
What is your income according to you?
I have paid 6,000 as in
Huh?
6,000.
Not what you pay, what is your income?
What is maybe 10,000? I am a daily basis in a village.
Hmm.
That is the highest. That is also not confirmed. Child court has awarded 6,000.
No, you have 10,000. Why can't you pay 5,000 to the wife?
I have an ailing mother.
Hmm.
I have filed divorce petition. Thereafter, she has filed this proceeding.
Pay 4,000. When was the order?
Order on 20/1/2024.
20?
20/1/2024.
21,
January.
2024.
24.
When was the petition filed?
2/5/2023.
2/5,
2/5/2023.
2023. It is 14 months.
14 months. 14 months.
Arrears comes to 56,000.
If you pay 50,000, I will pay.
Why?
Okay. I will.
Agreed with the learned counsel, the petitioner submits that the petitioner is a daily wage laborer and his income itself is 10,000. He has to support his ailing mother. All these aspects were not considered and court had granted 10,000, and it's very difficult for the husband to pay the said amount. Considering the submissions, he shall continue to pay 4,000 by 5th of every succeeding month. And the arrears for, I said, how many months I said?
14 months.
14 months. Arrears for 14 months. 14 months comes to 56,000. The same shall be deposited within 6 weeks from today. Either the 4,000 or this amount is not deposited, The stay granted by this court stands vacated without further reference to the court. Please take out notice on the counsel appearing before the court below.
Yes.
Post this matter on August 12th. Post this matter on August 12th, and the memo shall be filed by 3rd of August. Next.
For the respondent in the first matter, second matter, I am the petitioner. my lord.
My lords, kind indulgence, my lord. Kindly have it on day after tomorrow is the council or e-council is unwell, my lord. He's only seeking for 2 days accommodation. Day after tomorrow.
You appear for petition or
Petitioner Ashok Banedini,
at the request of learned counsel, the petitioner posts these matters on 8/7.
published. Day after, sorry, my lord.
That's how it is adjourned.
Lord,
Day
in
after
fact,
tomorrow.
How many times you will
I'm
ask
sorry, my
time?
lord, I'm because of the health reason, that's the only. Day after tomorrow.
copy of petition has not been served. I have no objection for adjournment.
Finally, post this matter day after tomorrow, no further adjournments will be granted. And today itself, the copy of the writ petition shall be served on the respondent, or else on that ground, the writ petition will be dismissed on day after tomorrow.
Sorry.
Yes.
Respondent.
For the petitioner, my lord. My lord, this is an unfortunate case where I've not, classic example of parental alienation, my lord. It's been 4 years, my lord, have not,
Before, let us see what is this IA 1/24, 2 of
not,
24. Yes.
dispensation of production of certified copy, my lord.
Certified copy of what, IA 1/24?
Annexures,
What are FG and H?
F, copy of objections to the IA that is filed under section 38 of Special Marriage Act. G is copy of the F, G and H, certified copy of IA seeking impugned order and copy of payments made. F, G and H.
Hmm.
We haven't received the certified copies, my lord, due to paucity of time.
Then what else you have filed?
Another IA for dispensation of type copy, my lord. We
No.
have filed a copy, my lord, not a certified copy.
Let's see where is the order. Order. The typed copy, where did you file?
We haven't filed the type copy. We're asking for dispensation of type copy.
Wherever is that order where you have
Reading.
filed, please show that.
Annexure F, my lord, page number 77.
I number 1/24. Mega. I 1/2024 is ordered, and prediction of copy of annexure F, G and H is dispensed with. 2/24 is allowed, dispensing with the protection of the type copy of annexure B. What is this manuscript in annexure C? What is that?
My lord, annexure C is the
Page number, where is annexure C?
65, my lord. That
60?
is, they had sought for an amendment of the plaint, my lord. The manuscript of the same, my lord.
No, first of all, why do you file? Where is a typed copy for this? Everything you dispense with, why do you file?
My lord, 10 days time, my lord, due to paucity of time, we were not able to file it, my lord. We will file it within 10 days, my lord.
No, they are not relevant to look into at this point of time.
65, no, my lord, it's not relevant.
A week's time is granted for filing with the typed copy of manuscript in annexure C. Yes, where is the order? Please straight away come to the order. Impugned order,
Annexure A, my lord,
page number.
18, my lord.
Who is the petitioner before this court?
The respondent, the wife, my lord.
Mother is before this court.
Mother is.
husband is before the
hus-
court.
In this court, husband is before.
That's what I want. Yes, please read.
My lord, orders on IA under section 155 of CPC filed by petitioner. My lord, the respondent files for an application for striking off of the defense. The defense is struck down on the basis of non-payment of maintenance. My lord,
Oh, you're saying about some parental alienation and all. This is about maintenance.
my lord, maintenance, my lord. What happens? This is all interlinked, my lord. I pay 3 lakhs, they say 9 lakhs arrears are there since the day of passing of an order for maintenance. Immediately, there's a special order for visitation also that comes up on 15/11/23. My lord, page number 39. There's a special order for his birthday. I was allowed to visit him. That time the court orders to pay part of it. So I would have paid 80,000 and subsequently 1.5 lakh. A total of 3 lakh would be deposited by that when the order was passed. The order says here, page number 39, this is the order for maintenance, my lord. 41 is where the order states, IA number 1 filed by the petitioner under section 38 of Special Marriage Act is hereby allowed in part. The respondent is directed to pay an amount of rupees 3 lakh to the petitioner per annum towards educational and extracurricular activities of his minor son by name Arun. My lord, I make a payment of 3 lakh. Even in that special order that is there in 51, the court, page number 52, paragraph 5,
What was the order of the court? How much the court has asked you to pay?
3 lakh per annum.
3 lakh per annum.
Per annum.
Where is that?
Same, my lord, same page.
That order is a
Number?
separate order.
Page number 41 is the
41.
When is this order passed?
2nd of March 2023. To the 27th of March 2023.
27.
27th March 2023. When is the petition filed?
2020.
2020.
16th
So
September
that means
2020.
2020 per annum, it would be from 2020.
120.
2021
September.
September. So till 2021 September 1 year, 2022 September 2 years, 2023 September 3 years. So you should have, by this time, you should have deposited at least 9 lakhs.
No,
9 lakhs.
no. 15 lakhs.
Nine.
Huh?
15 lakhs. No,
3 years.
it's for the academic year. 1920, 2021, 21, 22, 22, 23, 23, 24.
No, petition
sorry,
itself is
20
filed.
2021,
Huh.
21, 22,
No. Petition is filed in
2020.
2020. So
So
2021.
that's for academic year, not
22.
correct.
22,
23,
23.
23,
23,
24,
24.
And 24, 25 academic year has already started. It's for 3 lakhs includes educational expenses and maintenance.
1, 2, 3, 4, 5. 5
Five,
into three.
5 academic years.
Hmm.
15 lakhs is due.
Hmm.
What is
Yes.
paid is 1.5 lakhs.
3 lakhs, my lord. They have not raised any objections in the trial court and that has been recorded in the order as well, my lord.
Why is he not paying? To the
My lord,
son?
what happens here? The special order gets passed saying, go meet your child, make the payment of 1.5 lakh. I go to Bandra court, that is where the child lives. I go there, my lord. She calls me and she says, deposit 11 lakh. I'm not going to show my child. There's a police dairy report also that I filed. They make a submission. They state to the police saying that I've approached this court, high court, for the visitation. That is why I don't want to show the child. My lord, they've been going and taking this contention. My lord, annexure N, page number
No,
114.
Please tell the court, where did you take all these contentions now you're submitting before the court in the IA? Or where is it contended before the court below? You're making some submissions before the
See, my
court.
lord, we have
Where are they? Where are they recorded? Where are they advanced?
we have filed objections as well, my lord, for the strike off of defense. There we have made a mention about all the payments that has been made. That is 3 lakh. My lord, we have not even been given sufficient opportunity to make a payment. In the special order, the honorable judge,
What is
in-
this special order? I'm not able
for
to
the
understand.
birthday, we file an application for visitation of the birthday.
Yes.
From the date of visitation orders that has also been passed and it has been allowed, on the same day maintenance order has passed, that is 27/3/23. The same day, the court, honorable court, trial court says, monthly once, every third Saturday, you're entitled for visitation in Bandrack court.
You're
Even
mixing
that,
two different issues in this.
my lord, that is the reason my lord, I make
She
a
is
payment.
not, if she has not, whatever that order passed by the court, whether she has not obeyed it, your remedy is somewhere else.
Indeed, my lord.
Yes, now we are here on a point, your defense was struck off, right? On so and so ground. Now, when an order is passed by the court and as per that order, if it is any order that relates back to the date of the petition. So from that time you have to pay. You have not paid, court had passed this order. What is wrong with it? Now, with regard to all that visitation and all, don't mix up in that. You come up with a separate petition, it would be considered in a separate petition. So what's wrong with this order? Please tell the court.
My lord, in the special order, the judge, the honorable judge, in paragraph number 5, page number 52, they make a mentioning that in this regard, both side counsels have relied upon the reported decisions as cited above. As per the decision of Honorable Supreme Court in Rajneesh versus Neha, an observation made therein, it is very much clear that the maintenance has to be awarded from the date of the order.
That's what I read it.
And-
I read it. I read the whole order. That's what I'm saying.
My lord, it was not clear even to the date.
There won't be any clarity. You don't require. All
Indeed,
the
my
time, the order, please look at the order of granting maintenance. It would say it is from the date of petition.
Indeed, my
Ah.
lord. My lord, but sufficient opportunity was not given to me, my lord. The whole, within span of 7
Is
months,
order passed asking you to pay maintenance?
27/3/23,
27/3?
23.
When is this order passed?
2nd of March 24,
So that 1 year time is not sufficient.
sorry, 4th of March.
My lord, we've paid 3 lakhs, my lord. Remaining 9 lakhs.
Don't make the same submissions again. Why 3 lakhs? Why 3? Why should you pay 3 lakhs when you're supposed to pay 15 lakhs?
Lord, have not even been, they have been holding upon us for non-payment to visitation. They have been connecting those two matters, my lord. I don't even know if my child.
Unfortunately, if you say that they are not permitted to visit the child, that is a separate order. That is nothing to do with this impugned order. Now, this impugned order is passed on the ground that you have not paid the money, maintenance as granted by the court. That's a simple, why you have not paid is the only question. When are you going to pay is the next question.
We will pay, my lord. 6 to 8 weeks time may be given. I will deposit here only in the High Court only, my lord.
Why?
I'm willing to pay.
Why you want again 6 weeks? Now 1 year is over anyhow.
My lord, I have to arrange for the amount, my lord. I'm willing to pay, my lord.
What is your annual income?
28 lakhs 80,000 rupees.
And you have to arrange for it. And you would have made by this time 3 lakhs, like that. You would have paid by this time.
My lord, I have no issues of paying, my lord. We ask for them in the trial court to submit all the necessary, the receipt of the school, whatever it is, I'm ready to reimburse, my lord.
Unfortunately, a court had passed an order. Order do not contain whatever you want to say. I did not, if you're not happy with that order, you should have questioned it. You didn't question it. No, you cannot ask all those things, but you have except to pay the money. Now you have to pay. When are you going to pay? If you pay
will pay, my lord.
When?
6 weeks.
6 weeks is a long time. Do one thing. You pay half of the money in 2 weeks, half of the money after 2 weeks from now onwards.
Okay, my lord.
Yes.
My lord, and also there's another petition that has been filed by them before this
But that-
honorable court.
But we're withdrawing the petition.
Or
But that
what
was
is the interim visitation order, my lord?
my petition. I'm going to withdraw that petition having become
So
infectious. I don't know why.
if
my
he-
letter-
if
My
you
lord,
don't,
kindly tag along.
no. If you don't withdraw, you know the consequences. Yes. We'll dispose of this.
Lord, there's only one submission I want to make.
Ultimately,
The matter is listed for judgment now because they're not participated in the proceeding for more than a year.
so when was it registered?
From
resort-
April, the matter is being listed for judgment. Now it's on the 12th of July for pronouncement of judgment.
A
Which
stay
year
on
is the
passing of
MC?
judgment.
2020.
2020.
No, from where are the proceedings to show that they're not cooperating with the,
I have the
with
order.
it?
I'm sorry, Lord.
If you have it, please pass on.
If I may place this is the printout of the website, the e-courts website. And if you watch, kindly see page 4 from second.
No, after 27th, it shows summon.
No, he was appearing. Sorry, it's not.
No, if you look at
clearing.
it.
He was appearing. He was appearing. I am for maintenance. The maintenance application was decided on 27th of March after hearing the other side.
It discloses this,
Very good.
after 27/3, summon.
Your Lordship received from 12th of
31/10, it shows hearing,
here. Lord,
3/11 hearing,
18 dates have passed.
7/11, what has transpired on those days?
Lord, the applications of my application to strike off the defense was heard.
Your objection is only on the ground of maintenance, nothing
Absolutely.
else.
I have
Not
no
that
objection.
they're
for
not, no, let there be, let there be effective.
I don't want to get an ex parte order, my lord. I don't mind doing, but some time limit may also be fixed because 4 years the matter has been pending before me.
The petitioner husband is before this court, agreed by the order passed by the court below in MC number 213 of 2020, dated 2/3, what is the date of order?
4/3/2024.
4/3/2024, whereby the court below had allowed the application filed by the wife under 151 CPC to strike off the defense of the husband. It is a case of the respondent here in White Act that the husband has filed a petition for dissolution of
Sorry,
marriage.
wife
Wife
has,
has-
Wife had filed a petition for dissolution of marriage on 5/5/2011. Out of the marriage, out of the wedlock, they're blessed with a boy who is 9 years old. Because of the harassment meted out by the husband, she had to leave the matrimonial home. And she left the home on 18/1/2020. In the MC that's filed for divorce, she has also filed an IEA seeking interim maintenance. And in that, an order was passed on 27/3/2023, whereby the court below had directed the husband to pay 3 lakh per annum towards education and extra curricular expenses of the child. The court had observed that the husband is in due of a sum of rupees 9 lakh from the date of application on 15/9/2020 till 15/9/2023. And the said maintenance amount remain unpaid by the respondent husband. It is stated that the admitted income of the husband is 28,80,000 exclusive of the bonus and other benefits. And despite that, he is avoiding to pay the maintenance. The objections are filed stating that the wife had abducted the son without his knowledge. Until date, she has not disclosed where the respondent's son is studying. He is ready to pay the educational and extracurricular activity fee as per the order, and he has paid a portion of it. The wife is asking the husband to pay 12 lakhs as arrears without spouse direction. The husband is not, he's not able to pay the maintenance to the son for the reasons stated above. And there was no willful, deliberate violation of the orders on his part. The court below, the trial court had discussed the judgment of that the husband has not preferred any order, preferred any appeal against order dated 15/9/2020. It is also stated that there is no specific order to pay maintenance in single payment from the date of application. When the husband has not challenged the order, its contentions are conscientious, particularly to the minor son, and accordingly allowed the IA filed with the wife. Agreed thereby, the husband is before this court. Learned counsel for the petitioner has stated about the parental alienation, how the husband is not permitted to see the boy, and unless and until the money is paid, the wife is not permitting the husband to see the child. All these contentions which are raised on behalf of the petitioner husband, unfortunately cannot be considered by this court in this petition, as the petition, the order that is passed with the court below is on the ground that the maintenance is not paid when there is an order by the court. It is submitted with the learned counsel with the petitioner that in fact he is ready to pay the amount, however he required some reasonable time. Learned counsel for the respondent wife submits that when an order is passed on March 2023, 27th March 2023, till now, they have paid only an amount of rupees.
No, according to us, 1.5 lakhs, according to them, 3 lakhs. There is some dispute.
They have paid an amount of rupees.
There is no dispute in the order that has been recorded. They've not objected to the same, my lord. It's recorded in the order.
No, according to us, 1.5 lakhs.
They have paid only an amount of rupees 1.5 lakh, which is disputed with the learned counsel with the petitioner, that an amount of rupees 3 lakhs is paid, and the same is recorded in the order. He submits that as it is a clear violation of the orders of the court, and this MC is of the year 2020 and 2020, and the court below had rightly passed the order and passed the order. Next part. Having heard the learned counsels on either side, there is a material on record. When the court below had passed an order on 27/3/2023, the husband is bound to obey the said orders, as he has not questioned the same by preferring any writ petition before this court. The contention that the time frame is not fixed, the lump sum amount, that there was no direction that he has to pay the amount lump sum. Those are not the questions which this court needs to answer, as the said order is not essayed And when once it is not assigned, is bound to pay the same. As per the, it appears that the petition is filed in the year 2020. No, for the academic year, the fees is for the academic year. That is for 2020, 21, 21, 22, 22, 23, 23, 24. And for 24 and 25. That is 5 academic years. That is as per the order passed by the court, it comes to 15 lakhs. So the remaining, as it is stated that they paid 3 lakhs, the remaining amount is 12 lakhs. The husband is bound to, the father is bound to pay the said maintenance, considering pay the maintenance. However, considering the submission of the land counsel for the petitioner husband, this court deemed it appropriate to set aside the order dated so and so,
4th March 2024.
4th March 2024, on the condition that the father shall pay an amount of rupees 6 lakhs by 22nd of July, and by 5th of August, another 6 lakhs. As this is a MC of 2020, and this court has also perused the order sheet, the court below shall proceed with the matter as expeditiously as possible and dispose of the same.
My lord,
Lord,
one
may-
submission, my lord. The maintenance, there is no mention about the academic year that has to be paid. It just says per annum. That is what the order says for maintenance.
Lord, may I make only one
Page
request?
number 41, my lord.
The-
The respondent is directed to pay an amount of rupees 3 lakhs to the petitioner per annum towards educational and extracurricular activities of his minor son by name Arun. Doesn't mention academic year. It's just says per annum, my lord. So from 2020, 21,
is right.
22, 23.
What she says is
Correct.
right.
2020, 21 is first. Lord, for educational expense, I have to pay the school
Here
fee.
it is something like this.
Yes,
Now, you filed the petition in September 2023.
correct.
So that whatever annum, that's
Yes.
September 2021 or 2020, when is it?
2020.
2020.
September 2020.
Yes.
So it is September 22, September 2021, 1 year,
Yes,
1 year. 2021 to 2022, 2 years.
Yes.
2022 to 2023, 3 years. 2023 to 2024, 4 years.
yes,
That would be till September.
yes.
Then we still have
Very
the
well.
time for
Lord, very well.
this.
9 lakhs. Let them pay 4.5. In September, let him pay the remaining 3 lakhs. Lord. Again, this September will be the 5th year. He'll have to pay another 3 lakhs in September. I'm okay with that. Lord. Let him pay
Even-
let him pay 4.5 lakhs on 22nd of July, 4.5 lakhs on 5th of August. That is 9 lakhs.
My lord, this 3 lakh will pay at later stage, my lord. First we'll finish, we will complete whatever that is there. 9 lakh will pay. We'll make a deposit. 4.5.
Very good.
Yes.
We'll have time. Till September, we'll make that
Now it is-
payment.
By September, it would be 4 years.
By
Five.
September, 4.
September 4 years concludes, my lord. Therefore, 9 lakhs is due as of now.
21,
Yes.
22, 23, 24.
Correct.
4th September of 2024 would be the 4th year.
4 years complete then. 5th year starts from 5th of September.
You are looking at 2020 September.
Yes.
So 1 year, for 1 year means September 2024, 2022 to 2021.
Correct.
September, that is 1 year.
Correct.
22 second
2
year.
years. Yes.
23, 24.
Yes.
4.
So 12 years as of before September 12 lakhs to be.
4 into 12.
Correct.
Out of that, they've already paid
3
3
lakhs.
lakhs.
1.5 according to us. That's
That's not
the-
Yes.
The whatever that I'll record.
Yes.
3. So 12 minus 3, it is 9.
9.
9.
Very well.
4.5, 4.5. Make it
My
four
lord,
and a half,
minus 3, my lord, we still have time till September 9th, my lord, 2024. We'll pay that in due time, my
Sorry,
lord.
but
6
educational
lakhs,
expenses to be
3
paid.
lakhs, we will pay now, my lord.
What is that?
3 lakhs we'll pay now, my lord. Within, after the completion of these 3 lakhs, 6 lakhs that is due, we still have time till 9th September 2024. By then we'll make a payment of the 3 lakh that is there for this year.
No, for half of it. First is,
20 seconds.
now that is 6,
According to the 9 lakhs is due, according to 7.5.
9. 9 plus, this is 1.5. 10 and a half.
Yes.
10 and a half. 5, first installment 5, second is 5.5. 5.5. No, remaining by September, another 1.5 she has to pay. Half, till now, 1.5. Another 1.5 she will pay. And with regard to the husband, according to the counsel for the husband, paid 3 lakhs, and according to the counsel for the respondent, it is 1.5 lakh. The court below shall consider the same based on.
Obliged.
My lord, 1.
Now we have counted it 3 lakhs. If it is 1.5 lakh, then you will be entitled for that.
Very.
My lord,
My lord, the
1
time limit, my lord, for the court to dispose of the matter. Because
As
4 years.
expeditiously as possible. Yes.
My lord, 1 clarification, 4 years till date from the filing, 2020, 21, 22, 23, 24, 4 years. 4 into 3 is 12 lakh. 12 lakh is my balance. I've paid 3 in that. So it is 9 lakh, that is my balance. So it is 4.5, 4.5, my lord. 5 lakh, 5 and 5.5, that is what it says. 22/7 have to pay 5 lakh. 5/8/24 have to pay 5.5. But my balance is 9 lakh. 3 lakh is already paid, and that has not even been
That is
objected
not
by them.
deducted.
Sorry, madam.
No, it is 4 years.
Very well. I think she's right with calculation. She's correct.
4
4 and
into
a half,
3,
4 and a
4
half.
into 3 is 12.
4.5 and 4.5 would be due.
No, 12. In that she paid 3. So it's 9 lakhs.
9
4.5, 4.5.
That's correct.
But
In that,
if
I
again,
only pay
and
1.5.
again, if her calculation has to be taken, it won't be 9 because the September is yet to come.
No, educational expenses I have to pay in adapt.
No,
School will not
that-
take it.
that
Will not
4.5, 4.5.
Very obliged.
Yes.
Match objection.
Here for the caveator respondent wife, my lords.
This is a case where in the Gulbarga family court case, the matter got settled. 31(1)A petition came to be allowed. And in the compromise petition, I undertook to pay all the educational expenditure of a child, minor child, who was born in America, but still they have been subjected to the jurisdiction at America. Sorry, the Gulbarga court. Now, my lords, there is a visiting rights agreed between the parties every Saturday and Sunday to the father. This is a father's petition. Now they moved a 7 GNW application year after the decree, and we filed Order 7 Rule 11 application. Once there is a compromise in the Gulbarga court, any differences will have to move before that court only. There is no question of an independent application filed before the Bangalore court. That too when the divorce petition was pending. The GNW petition was filed.
Let us see that compromise decree.
Yes, my lords. Page 49, my lords.
Yes.
Paragraph 19.
Yes.
Further, it is to be taken note that the respondent in his affidavit evidence has denied all sorts of allegations of cruelty made against him. However, he admitted that subsequent to filing of this petitioner, in view of the intervention of the elders and the well-wishers of the family, the respondent and the petitioner have settled their dispute out of the court and decided to end their marriage tie by a decree of divorce. Accordingly, the respondent has paid a sum of rupees 15 lakhs to the petitioner as a permanent element. Accordingly, the respondent has no objection to allow the petitioner to dissolve the marriage of the petitioner and respondent by decree by it is to be taken note that the petitioner has not chosen to cross on so. Then, my lord, there is a reference to 15 lakhs. The operative portion of the decree is at page 51. The petition filed under 31 1
Where
A.
do you get about the visitation rights?
My lord, your lordship takes at page 27. It is an extracted. Para 16, page 26. It is a case of the specific race, ink page 26. Para 16. It is a specific case of the respondent. There was
But
a
it is not
settlement.
find part in the decree.
Yes, my lord, that is a problem. In fact, I am abiding these terms of the, but I am not having any visiting
When is
rights.
this compromise decree passed?
2023, my lord, 11 to 2020, sorry,
11/2/2000.
no, sorry. 15/3/2023.
No, please come to the impugned order.
Page 54, your lordships get date of the institution, date of the disposal, page 54, ink page. Date of the institution and date of, then this GNW was filed when this petition was pending. Page 59, GNW was filed on 17/12/2022.
17?
12,
Hmm.
2022.
No.
This
if-
registration was after the decree. GNW was moved on 25/7/2023.
25?
25/7/2023. And the decree, my lord, of divorce was allowed on 15/3/2023.
Please come.
But
to
I
the-
am prepared to, whatever your lordship suggests so far as bringing up a child is concerned, I am prepared to do
No,
it.
no, let us see, first on the technical aspect of it.
Yes,
Then we'll
madam.
go to the other issue.
In fact, all that, my lord, I am only appealing to your lordships. In view of my lord Justice Ravindra J. judgment 2005 6 SEC 566, wherever there is a compromise, there is no appeal, no review. Parties are relegated to only that court. In fact, I suggested to this.
No, but unfortunately.
No, I
This-
suggested, since instead of having one more trial before a district judge, we can have, my lord, via media here itself. All that I am interested. I am getting a 2 lakhs rupees. I am a software engineer. 2 lakhs rupees. After that is a take home salary. Gross income is 2.83 million. Now I am taking all educational expenditure which comes to 30-40 lakhs. Now the respondent is working as a lecturer in business management and getting around 40 to 45 lakhs. Even if she is willing to come and join with me, I am prepared, number one. Number two, whatever, my lord, your lordship suggests so far as the reasonable medical and educational expenditure, I will advise the petitioner to pay it off. But I want a visiting rights on Saturday and Sunday, where it has been agreed, my lord, in the
No,
compromise.
let's go to what is the order impugned? That we will see and then. we'll
Annexure
go to
A,
the-
my lords,
uh,
13th of June,
Page
2024.
number?
Page number 16, IA number 5, I filed an application stating that there is already a compromise. So the matters have been settled. Therefore, if at all there is any extra claim, she has to go to Gulbarga court. And the court held that the application is not maintained.
The reasons are from page 23. of the court.
We pressed for a principle of res judicata.
You have no difficulty declaring her as a guardian of the child. Only you want visitation rights, nothing else.
Of course, my lord, that is the compromise which has been made.
What is the difficulty?
I
Why
am
can't my
prepared to,
lords-
I
why
am
can't you have
prepared to
visitation?
accept
No, no, 1 minute.
for any terms and condition which is reasonable, my lord, in the interest of the son, I am prepared to.
May I submit?
Even if she is willing to come and join, I will receive her. That's the position.
My lords, in the court in Kalburgi, divorce petition was filed by me. There is no compromise petition as my
No,
learned
that I
friend.
have seen. I'm
There is no,
saying-
no, I want to submit an IA under Order 7, Rule 11 is filed for dismissal of my guardianship and custody case on the ground that orders on guardianship and custody are passed. By a compromise petition, my learned friend, my learned senior counsel has submitted. The decree of judgment of divorce passed is not a consent decree. It is a decree of, it is a judgment of divorce which has been passed where there is not a whisper of anything relating to do with the child. Neither custody, nor visitation, nor guardianship, nor maintenance. I just want to make a submission, kindly see.
I've seen that order.
Yes, my lords have seen that order. And the only submission made there was that they went, they settled on a permanent alimony for her for 15 lakhs.
Yes.
On that, noting that the order is petition under this by petitioner wife is allowed, marriage between them is dissolved, and the court records that the 15 lakhs has been paid. It is not a consent decree or a compromise decree. Thereafter, I have nothing about the child. I don't get any order on on maintenance for the child or guardianship, and I'm constantly being threatened that they will take away the child from me. So I filed during the time when this petition was going on. I also, since I have moved to Bangalore, GNWC can be filed as per the provisions only where the child is ordinarily residing. So I filed for.
When did you come to Bangalore?
I came to Bangalore, my lords, just after the petition was filed there, I moved to Bangalore here because I started doing a course. I started studying because I was thrown out of US. I started studying here and I moved to Bangalore. I filed my GNWC in Bangalore. What the learned family court judge has very clearly said, may I just refer to page 24 onwards. This is not some general thing that every matter can come before the Honorable High Court and all matters can be opened up. There is a proceedings going on. Kindly see, my lords, page 24, para 12.
Yes.
May I read from para 12? It is well settled law that at the time of considering an application under Order 7, Rule 11 of CPC, the court has to scrutinize the averments in the plaint. At that stage, the case of the defendant in the written statement is wholly irrelevant as the application for rejection of plaint has to be decided only on the averments in the plaint. If clever drafting has created the illusion of a cause of action, it should be nipped in the bud at the first hearing by examining the party under Order 10 of CPC. This principle is laid down by the Honorable Apex Court in decision in so-and-so in case of Church of Christ Charitable Trust versus so-and-so. Next, para 13. Para 14. It is the specific case of the respondent that custody of the minor child is already settled in MC number 286 of 21. Therefore, the present, my lords have seen para 14.
Yes.
Therefore, the present petition is barred by law.
No, I'm with you on that.
Yes.
So we don't have to go
Yes.
further on that.
So
Yes.
the dismissal of the IA, this petition is filed impugning the order, dismissing their IA under Order 7, Rule 11. Now, I have filed for, I am seeking maintenance for the minor child. My learned friend says, I will give anything. He has merely stated in his own affidavit of evidence in the divorce petition that I will give 3,000 rupees and school expense for the child. That is his own unilateral wish. There is no settlement. There is absolutely no settlement arrived at. In fact, even the GNWC case was referred to mediation and he refused to pay any reasonable maintenance. I have filed my affidavit of assets and liabilities. I have filed an application for maintenance of the minor child.
Let him file his appropriate application, please.
Yes,
ask.
exactly. Let
IA
All the
IA for restriction
kindly-
rights and all.
he can file it.
page 27 minutes.
Yes.
In page 27, I am paying whatever I agreed in the affidavit, number one. Why there should be a dispute, my lord, between the welfare of a child, between these two people, husband and the wife. Both of them are earning. And I agreed to pay 3,000. Then, my lord, the educational expenditure, which I am paying, there is no denial. It has been recorded. Now, the short question is, I am entitled for a visiting rates, my lord. on
Correct. When you
Saturday.
file an appropriate application before the court, it will consider. If it doesn't consider, we'll consider. If you come before the court, now as far as rejection of plaint is concerned, it won't arise. That order has to be upheld.
Your lordship, I will permit it to withdraw the petition with liberty to move an application.
The after advancing the arguments, that a permission is sought to withdraw the writ petition with the liberty to pursue the remedies before the court below, before the trial court, accordingly dismissed.
Great.
Petition dismissed. Yes, next.
To move an appropriate application.
Yes.
For the petition, Lord, last time, Lord, I filed the documents, that is copy of the sale deed, Khata certificate.
Documents.
Today,
Given him a copy of it?
Yes, ma'am.
today copy is served. I'm told that not my counterpart, respondent, Lord, is held up in another court. He requested me to have this matter tomorrow.
By tomorrow, no, as per that, how much is the extent?
No, Lord, as per that sale deed, the portion that was sold in my favor is excluded. And it seems, Lord, that sale deed is not even acted upon because there is no kata transferring her rights, Lord.
Oh, 1 minute. That's why before adjourning the matter, what I want to make clear is.
Yes.
So what about that, whether it is genuine, not genuine, acted upon
Yes,
or
yes.
not? No, that's not the stage where we are
Yes,
in
yes.
now. No,
My portion is excluded.
what was the extent felt to the share of the vendor?
1/4 share.
What is that?
1/4 in the entire property, Lord. That's the problem. It is not determined, Lord.
Now, what is the entire suit schedule property?
Entire suit schedule property.
Give the file. So that again, instead of wasting on that, please you can inform your colleague also on this. So that he can also come up with instruction. Let us see where is the judgment and decree.
Trial court judgment and decree not produced.
It's not there.
Not produced. Last time, submitted a copy of it.
No, it's there, see. You filed it or you're passed on?
Handed it over. Produced at the time of argument.
No, once we know what is that, whatever share of your vendor.
Yes.
Then what is sold to you, what is his, what is sold to you, then basing on that, we can understand what is it.
Yes.
What is sold to him as per that document?
As per that document, Lord,
It contains a mention about your share also. That what is sold to you.
Lord, my sale made in my favor is not disclosed. What she says, Lord, in the sale deed is that, Lord, the portion mentioned in the car, Lord, have copy, Lord.
Take the copy.
Sketch. Last document, Lord. Last document, sketch, your lordship got it. That corner portion, Lord, that is not sold to him. Remaining portion only sold.
No, remaining portion means they must have specified it extent.
Yes, Lord. That is, Lord,
130.44 square feet is what is sold to him, I think.
yes.
What is sold to you?
In my favor, my lord, it's 32 by 18 feet.
How many square feet it would be?
Square feet, 32 by 18.
Give the calculator to him.
576 square feet.
576
Yes,
plus 130. Totally 706. 706.444.
yes.
So now the next issue would be how much fell to the share of your vendor?
1/4, my lord.
1/4 of?
1/4 of this entire property.
1/4 of the. So the entire suit schedule property of the partition suit is only this.
Only one property.
Only one
Yes,
property.
yes. That's the problem.
It is how much of it? 1/4 of it.
Yes,
1/4 would be
1/4.
1/4 of 706.444.
176 roughly it comes.
170.
176 square feet.
One 130. Yours is 576, this is 130. Then now in this 176, how much both of you are ready for is the only question now.
That I will put it to my client.
Please put it to your client instead of tomorrow, day after, so that you'll get some reasonable time.
Yes, no, day after tomorrow.
Day after tomorrow. The land council respondent is here.
Sorry, my lord.
Now, the share that fell to your vendor, both your vendor, is 176 square feet.
Please, ma'am.
He purchased 576, you purchased 130. So proportionately should be the your arrangement.
My lord,
Please put to your client and
my client.
we'll have it on day after tomorrow.
Much obliged. I'm sorry, my lord.
Right. Pose this matter day after tomorrow at the request of both the councils.
So there was a direction for them to give a proposal. There was a direction for them to give a proposal on the last date. But they have not given us any proposal so far.
No. The trial, this honorable court observed that all this can be sorted out in the trial court. Let the trial court decide it. Because what they want is the divorce. Right now, in this proceeding, he wants a divorce from the petitioner. I put it to my client. She says that, no, sir, there are other issues. And she has filed divorce petition. He has not filed objection so far. Other issues are there that may not be possible is my client's answer. That is the answer. Correct?
But no, she filed divorce petition.
They're giving a divorce, take divorce, we say.
There he wants to give. Why she says no, only what issues are left in a divorce petition, that alimony and the child issues.
My lord,
As far as the divorce is concerned, he is ready.
my lord, there is,
He wanted to have a contested divorce.
yes, because of this annexure B series up to the annexure E series in this petition. And this man has another, my lord, after when the matter was going on, he is in relationship with.
I'm so sorry, Deshi. The point is, they cannot
No,
hold
if
the
it is
children
the
at
way-
ransom.
If this way every 1 minute you want to reply to him, it's very difficult. You please be seated. Once let him complete, then you can come back. Yes.
My lord, there is, he is in relation with another person who is married, and that person has filed the petition for divorce. Here, with all these allegations, the respondent wants to get away with that by seeking divorce without any terms. And the allegation, Your Lordship, I have placed all these on record. The serious allegation, all this has been done. He wants to get away with it and he wants to marry that woman. So she says that she is not ready for this divorce. That is without, let it be a contested divorce. She wants to
contest the case.
Anyhow, if that's what she wants, go, we can't do
Yes, ma'am.
anything.
Yes,
But why she wants, like, what is the advantage she'll be getting out of it?
my lord, I could say few words to her. More than that, she is a matured person. She is an intelligent
But
person.
what the advocate can
Therefore,
do,
yes.
but ultimately,
I-
she has to think about her future and the
Her
kids.
future.
And,
yes.
going around the courts, fighting it for the sake of, ultimately,
Is-
end of the day, or down the line after 10 years, she'll realize that.
My lord.
But by the
all
time,
this-
it would be a very long time.
My lord,
Whichever, nobody can put the clock back that time.
yes, I could put in a word or two to her, and she strongly feels that she is
Let
not,
her, let her,
because
if that's her-
the
if that's the way
annexure
she
B
wants it.
series, C series and all that, he continues to do that and gives a different picture to the court, does not file.
Court, even for a minute,
Yes.
is not going into any of the picture either given by the petitioner or by the respondent. Those pictures, the trial court
Yes.
would see
Yes,
whether it is painted or it is a
Yes.
real picture.
yes.
Now, as
yes.
far as the court is concerned only with this interlocutory application.
Yes.
That's fine
About the,
before the
about the
court.
custody, my lord, one submission, when the custody of the children, these two small children are concerned, because one is born on 2000, in the year 2014, another is in 2016. The girl child is only about 7.5 years. All these allegations, maybe right now they are allegations, they also play a major role, is my respectful submission, because the character of a person is very important. No doubt he is the father, that is not. But having regard to the character of this person, whether it would be,
Now, at this stage, at
Please.
an interlocutory stage, now what are your allegations, the counter allegations, their defense and all, the court cannot go. And as far as the kids are concerned, he needs to have the visitation, what kind of it will be
visitation,
decided.
yes, madam.
No, to that extent, the court would pass order. Remaining things, the court will,
Yes,
the trial court
I am
will decide.
obliged. Therefore, now coming back to the case, my lord, page 127.
Yes. First, we'll be going to the order of the trial court.
Yes, ma'am.
Yes.
Yes.
Page number?
127, that is the operative portion.
What is the date of order?
Date of this order is 24. Hold on.
21/12/2023.
24,
Hmm.
23.
Hmm. Yes. Oh.
My lord, first, the respondent father is allowed to take both children between 2 p.m. and 6 p.m. on every second and fourth Saturdays. Both parties are directed to mutually agree upon venue in order to facilitate. On that, we are.
Yes.
First, the respondent,
Hmm.
there is no, my lord, the petitioner has no objection for this first one.
Hmm.
Next. The respondent father is entitled for interim custody.
You said what is the age of both the child?
My
both the
lord,
children?
one is, my lord, the Ishan was born on 25/12/2014. So he is about
10 years old.
9 years, 6 months old.
10 years old.
Yes,
Yes.
ma'am.
The other one is?
The girl is born on 18/11/2016.
He's 8
She's
years old.
7 year and,
9 and
yes,
7, Division. 9 and 7. Ages are 9 and 7.
9 and 7.
Yes.
Yes.
the second, the order, the respondent father is entitled for interim custody of both the children during the last 10 days of each month of April and May summer vacation. That also spent. Your lordship passed orders on this. That is next.
I think it was like, where did he had the custody?
Custody.
It was not a custody. He came here and he
No,
just
no,
like
this,
a.
entitled for interim custody.
Uh.
On that, this court heard and made arrangement for
And
the,
whereby he was permitted to stay in Bangalore and
Yes.
exercise the
Ye-
visitation right.
yes. And
Ah.
the continuous days interim custody was
Mm,
also
yes,
given
yes.
from morning
That
till.
we have to look into now while passing the order.
Please,
Next
madam.
three.
Next is.
The respondent father is entitled to have video conference. This is
The
going on.
respondent father is entitled to access to the children through video conferencing for 30 minutes on Saturdays and Sundays. This can go on, my lord.
Hmm.
And my lord, during the summer vacation, it was modified and it was followed as per the respondent husband is entitled to visitation right to children from 5 p.m. to 7 p.m. on major festivals and birthdays of the children. In this, court need to dwell on this and say which is the major festival. Generally, Hindus, Diwali is the festival. Diwali is the festival. Therefore, on that, court may kindly clarify this position. Visitation right between 5 p.m. and 7 p.m. Even birthdays of the children, because he is a father, visitation, I think it may not be, it can stay. The petitioner and respondent shall not force or create any situation which would cause embarrassment to both the children during the above said periods. My lord, somewhat there is understanding between, because of the court order, most of it is fully complied. And an affidavit is also filed by the wife that is on record on 19/6/2020.
Stating what?
Stating that one day there was a little disturbance. I may be permitted to. Now, this is mostly, my lord, because there is another petition by the father.
This is dated when?
This is dated, it is 19/6/2000.
It is there.
Yes.
19/6/2024 is the affidavit.
Yes,
What are the specific allegations?
yes.
These are all about 5, 6 about his conduct.
A little more than that. My lord, paragraph 6. I submit that both the children are minor and of impressionable age. The respondent has often put them in a position where they are exposed to his extramarital adulterous relationship, with the children being used as pawns to further his interest. The children have been introduced to the adulterous partner as a naive mummy or new mother, and this is distressing and unacceptable for the emotional well-being of the children. I further submit that the children is still engaged in the respondent is still engaged in the adulterous relationship with the Mrs. So-and-so. A copy of the screenshot of the WhatsApp conversation of Mr. Ketan Manik, admitting of the adulterous relationship of the respondent with his wife, is filed at Annexure 1. I kindly see Annexure 1, my lord, if I am permitted, because that is still continued. And this is the person who is asked to call the mother, that person as Naimam. Now kindly see the Annexure 1 at page 8, my lord. This is the husband of that person, my lord. April, finally, from past 2 months, I and so are separated for good under separate home. My lord, divorce petition is still pending. I know you have decided not to stay in touch, which is perfectly fine. I guess it's too late. But yet, in case you need any help regarding all proofs that I have, feel free to contact. Then, sorry to hear the development. It is from my end, my lord. At your family, it is hard on the children. You may kindly share anything that can help. As it may help me in safeguarding children's well-being. Do not mind sharing. Last line. I have made a bigger fool of myself by reconciling and restoring our marriage last year until I came across her very intimate messages with the Goldie in February this year. Next page is Annexure 2.
kindly. This is during the visitation, this visitation which court permitted, my lord. And 19/5/2000, it was sent to the respondent hearing by the petitioner. Ishan misbehaved for 50 minutes yesterday. From throwing paper, he moved to throwing stone. This is the
Please
complete.
come to this page number 8. I read that.
Yes,
Page who is this? What is this conversation?
my lord, this is the he is in adulterous relationship with a
How
person.
come she is having all this?
Yes, because that person messaged her that he knows that this person has an adulterous relationship with his wife. The person in Bombay has sent this. He said, all along we were friends, we believed him. Now that I have come to know of his adulterous relationship with my wife, and if proof of all that is required in your case, and if it is of helpful for the in your case, then I am ready to send it. That is what the affidavit also states. Next is annexure 2 is from the respondent to the wife, that is petitioner. Ishan misbehaved for 15 minutes yesterday from throwing paper. He moved to throwing stone. He misbehaved big time with his bar. He said, I am a kid and I can do whatever, nobody can stop me. These are inappropriate situation and he needed to know this is unacceptable. I just gave him a stare which was needed when he was throwing stone at me. Finally, that's what stopped him from misbehaving. I am waiting in your car. Please share the day's plan. Please don't blame the children. This is from the wife. No point in rough behavior or scaring them. That is all I am trying to convey. Then it continues. Then he said that I was continuously calling the children. It is not so. Bunny.
Yes, I've seen.
Yes. And ಬನ್ನಿ ಮೇಲೆ ಸ್ವಲ್ಪ ನಿಲ್ತೀರ. My lord, paragraph 7, may just I will not take much.
I have read it.
Please, please. So the elder boy, he is scared. He is scared to go with him because so many times he has scolded. That is what the affidavit says. And with these small children, giving the right of custody, overnight custody to the children, it may not be in the best interest of the children, because what these children also now started doing it, they know their own plans of getting away with it. They are very, very reluctant to go with the father. Though there is an order of the court, the petitioner obeyed it. And she told both the children, go, there is a court order, you need to go. They are refusing to get out of the car. And the small child, it fell on the floor of the car and refused to. What she can do? She cannot drag them out of the car. Finally, she gave the key to the respondent, you take care of the children. Now, they are also, they know that their mother cannot do anything because they requested the mother not to send them, but that is not happen. That did not happen. They also started playing their own games. They don't want to go at all. This is the factual situation I could gather from the conversation. And because otherwise, my lord, otherwise, this is my submission. Otherwise, in normal circumstances, children, the father has the right for visitation and maybe custody of the children. But here is a case where because of the father's behavior and the character of that person, it is not congenial to the children to be left with the father, because he has the habit of drinking, he is the habit of going out. The children are taken to the room, hotel room. What he does is no one can control, except that she can telephone and video calls. overnight, if they are left in the hands of this person, he will go out. He has the habit and he continues with his habits. And it is very, very, I must say that dangerous also to leave the children separate in the room and he goes on with this, the other interests. Therefore, I submit that overnight custody of the children, visitation, as this court said, and other maybe extra time for visitation also this court may think of, and video calls also this court may think of it. A reasonable order may kindly be passed is my respectful submission. Please,
Yeah.
madam.
Leadership, before I proceed with the matter, on the first point on the mediation, the court exercises parents' matter jurisdiction, as I said last time. Now, the fact of the matter is that this is in the interest of the child not to be in the crossfire of a matrimonial dispute. It's in the interest of the child and nobody else. Now, her reasons are, I will teach him a lesson. I will be vindictive. I will show him where he is. This is her reason. And who's getting caught in the crossfire? It's the kids. She will, after a few years, whatever, the fact of the matter is, the sufferers are the children in this matter. What if she can, even assuming she manages to prove something in the court, she'll get a divorce. By proving it, whatever she's trying to allege, she'll get a divorce. Now the point, but who suffers for all these years in the process? Because she will definitely not want me to even see my children even once in the process. So, Ladyship, my humble submission is, I will argue just now that as parents' matter jurisdiction, there is a judgment of Gaurav Nagpal which says that court is not bound by any statute when the court is deciding in capacity of a parents' matter jurisdiction, which is in the interest of the child. And my humble submission, interest of the child extends to resolving the matrimonial dispute because they will be affected most in this matter. Having said that, Ladyship, I'll proceed with the matter. Now, firstly, Ladyship, my learned friend is trying to raise all these allegations of adultery, etc., etc. Fact of the matter is, all these allegations have been considered by the trial court. We have given several judgments passed by various high courts in which the court has said, in the case a mother is adulterous, that does not mean that she's a bad mother. The judgments of the Delhi High Court which says if the mother is adulterous, that does not mean that she's a bad mother. Judgments of the Bombay High Court, Karnataka High Court, we've all given all these judgments before the court and the court has relied on these judgments. It's there in the order and has given me these visitations. There also they were saying same old thing again and again and again. So I will first read the impugned order, Ladyship, because that's the first point to start with, where the court has considered their submissions, whatever their contentions have been.
I've seen that.
Now, the court below has relied on Yashita Sahu heavily. And in Yashita Sahu's reliance, what the learned trial court has said, that in a matrimonial dispute, the court ought to be very wary of the allegations being put by both the parties. Each party tries to paint the other as a villain. These are the words of Yashita Sahu, which has been relied upon and referenced by the learned trial court and said that all these allegations, I don't think there's any exceptional circumstance. It is a matter of record, part of trial, it will be considered at that stage. Now, Ladyship, very interestingly, what has happened is that let's go through what happened in the visitations. Now, if the children are not happy with me, they will not spend 8 hours, which was the Ladyship's order of 16th of April. From 16th of April, for 6 days, 8 hours daily, the children spent with me. Every day they used to decide, let's go here today, let's go there today, etc., etc. And they were very happy. The next round, during the summer vacations, every weekend, the children spent time with me. On the 4th, in particular, on the 4th and 5th of May, I spoke to the children. Children said, I asked them, do you know when my birthday is? They said, yes, we know. It's on the 13th. We'll cut a cake on that day. We will celebrate. We'll go to Wonderla. They were all planning all these activities with me. Who got jealous? We don't have to guess. Next, 11th, when the visitation started, the children were not even sent to me. From 10 in the morning till 2 o'clock, the children was not even asked to leave because the mother got jealous. She got insecure because the children were planning a birthday party for me. She got insecure. Next day, again, it was Mother's Day. I said, you can spend the time with the children. I said, I don't want visitation. I'll only visit you for 1 hour. So, ladyship, what is happening when I go through the dates of visitation? Every single day, the children come, they create some drama. It's this. I also sit and say, okay, fine, this is, ticking the box. This will happen. And after some time, the drama is created. Then mother comes after watching the entire thing for 40, 45 minutes. She comes and says to the ear, and the children leave. This is the practice every single day. So, ladyship, what is happening is whatever familiarity I make with the children, I develop with the children, the bond I try to create, till the next weekend, it's gone. Because the mother has done something to brainwash the children. Rather, the children are scared of the mother. And one classic example is, ladyship would remember when the children were there in the chambers, they said, we only want to go to Kiddoland. We only want to stay there. We will have visitation nowhere else. But interestingly, each visitation, when I used to give them options, where all you want to go, Loco Bear, Wonderla, etc., and Kiddoland. I used to purposely say Kiddoland. They said, no, we don't want to go to Kiddoland. So the reason is because it was a mother's desire that they go to Kiddoland, because since the time of the passing of the impugn order on 21st of December, till the time of ladyship passed the order, the only place where the visitations happened was Kiddoland, because it was to their convenience. And I used to stand there, sit there, the children were inside playing there. I couldn't even go there and meet the children. They used to keep extending by an hour the playtime, and they used to leave. And then the mother has spoken a lot about eating junk food. When I've been giving them healthy food with bills I've attached now. And then in Kiddoland, every time they used to sing, they used to only have pizzas and burgers. So my point is, ladyship, these are issues which are being created, trying to say I'm not a good parent, when she is the one who is giving them all this kind of food. Now, ladyship, I will just go through the visit, because that is going to be sufficient for me to demonstrate that whether I can take care of the children or not. Now, for that, ladyship will see para 9 of my affidavit in reply to which they had mentioned. This was filed, ladyship, reply to the affidavit.
When is your affidavit? 1/7/2024.
We had filed 2 replies, ladyship.
One is 1/7/2024.
Yes.
Objections.
Objection to the respondent to the affidavit dated 14/6.
2024. Yes.
So 14/6, ladyship, I'll read that. Para 9, ladyship. Before para 9, ladyship will see para 5, because this is my submission. It is pertinent to state that while the children were happy and playful once the petitioner left, they were always made to create some trouble, during the time of handover, which clearly depicted.
Where are you reading?
Ladyship, I am reading para 5.
I think it is not this one you're reading. Para 5 is the contents of para number 1 being formal in nature. Second one. This is dated 10/6. 19/6.
96.
Yes, madam. Page number 2.
How can it be 19/6? His objections are 19/6.
No, ladyship, the 2 objections. One was on 14/6 and one was on 19/6. They filed 2.
Oh. Then you have filed 2 for 14/6/1, 19/6.
Yes, we also filed 2.
So this is your 19/6 to 14/6.
Yes. Now they should see para 5. It is pertinent to state that while the children were happy and playful.
Para number?
5, Lord, ladyship. Page 2.
Please read.
Yes. It's pertinent to say that while the children were happy and playful once the petitioner left, they were always made to create some trouble during the time of handover, which clearly depicted that they were brainwashed and tutored by the petitioner and were acting on her instructions. To please the petitioner, children used to pretend to not want to go for some time, and as soon as the petitioner and a father would leave, the children would become normal and playful with the respondent. The petitioner always came with the father. The action the petitioner depicts that she is extremely insecure and is well aware that the children would easily bond well with their father in the event she does not intervene. As such, to continue using the children as pawns to demand 10 crores. She has demanded 10 crores in the 125 proceedings, which she has demanded in the maintenance proceeding under 125. She is leaving no stone unturned to manipulate, brainwash, and tutor the children and is causing parental alienation. The petitioner has no concern about the psychological impact being caused on the children owing to the vindictive nature and selfish motives. This is the sum and substance of what I want to say. Then ladyship will come to para 9, which is the chart table. Now, ladyship, every single thing, look at the kind of activities. 27th April, respondent, I've given the pickup time, drop time, what food they ate. They went to which place on that day. Children were given options to go to Kiddo Land, Loco Bear, Time Zone, Fun Zone, or any other. Children said they love Loco Bear. Children had a great time as it did activities like wall climbing, zip line, trampoline play area, and even tried bowling. Then ladyship come to 28th April. Thereafter, we went to Ganesh Temple. And after that, we went to watch a movie, Godzilla versus Kong. 3 hours, the children are watching a movie with me. Will they sit across with a person whom they can't stand, whom they don't want to look in the eye? 3 hours. And this is nothing. Before that, it was 8 hours at one stretch, the children used to be with me. Ishan wanted to have a lazy day. He was keen to go for a movie. Arya agreed for it. They had already seen Godzilla versus Kong movie, but were happy to see it again. The respondent children first went to Ganesh Temple. Then the respondent children went to Meenakshi Mall for a show from 12:20.
Yes, so this is how it went on all the occasions.
Then every single day ladyship I have explained. Now 4th May is important ladyship. 4th May is when I brought the topic of my birthday. Till then they are taking me to their favorite rides. They're pulling me with them. Let's go to this ride. Let's go to that ride. 4th May. This is on page number 6 ladyship. Children initially showed excitement to go to a water park. However, the respondent and children needed to get the swimwear. So they stopped at a mall. Children were again very playful and delaying buying the water-related items. The respondent requested children to postpone going to Fun World for next day. The respondent called the petitioner to check if she can send the swimwears next day. On the call, she requested if the respondent could be given roti, naan, sabzi instead of burgers and pizza. The respondent agreed for that. Respondent children then went to Forum Mall Time Zone and played before having lunch. Children enjoyed playing and even were not keen to rush back. During lunch, the respondent asked Ishan if he knows his father's birthday. He quickly said the correct date, 13th May. The respondent told him that he would be happy to celebrate his birthday with them on 11th or 12th May, which is the next weekend. They suggested the respondent and children will cut cake. Also, they said since it's respondent's birthday weekend, they would love to go to water park as they love playing in water. So they agreed for a plan for the weekend of 11th of May. Then 5th May, which is the next day, respondent reached the pickup point at 10 a.m. and the children was handed over at 10:15. The children visited Fun World ITC Fortune near Fun World and had milkshakes, naan, pulka, etc., etc. Petitioner called the respondent to talk to the children. All the video call access I'm giving. The respondent and children went to Fun World and had a great time. On the way to Fun World, children played with the respondent in the car. They were sitting in his lap, pulling him, enjoying a great deal. Even at Fun World, children especially took the respondent to their favorite rides. Respondent and the children enjoyed, laughed, and played a lot. Once they came out of water, Arya informed me she doesn't like the washroom. Then he took them to ITC to ensure that she feels comfortable. This is, thereafter, ladyship will come to 11th of May. Now, respondent reached the pickup point at 9:55, but the petitioner left without handing over the children at 11:15. The children, it was surprising that despite a prior agreement with the children on the plan for the weekend, children behaved very weirdly at the pickup times. First time I'm using the expression. Shockingly, children refused to go. The petitioner got the children in the car and walked away. Children locked themselves inside. When the respondent asked her to get them out, she threw the car keys on the road, indicating the respondent to pick the keys and deal with the children. She eventually took the children back without handing them over. The respondent kept waiting at the same place for the next couple of hours. Then she informed that she will get children again after lunch. Children came back at 2:14 p.m. and then they saw a movie. Now this all action happened for 2.5 hours. And then the children happily came with me and saw a movie. And then she said, the children don't want to go, all the messages we see. And then she said, okay, I'll get the children at 2 p.m.
Yeah.
Now, ladyship, 12th May is only important to say that it was Mother's Day. I let the children go early. Now, 18th ladyship becomes very important how the son starts to behave purposely. The respondent reached the pickup point at 9:50 a.m. and children were handed over. These are the basically what all things were done. But children were misbehaving in the morning as if they were getting some kind of push, direction to misbehave. Ishan made paper balls from newspaper and started to throw at the respondent. Then Arya joined in making the paper balls and Ishan were throwing them at the respondent. As the respondent remained calm with this act, the petitioner's father was disappointed and asked Ishan to stop it. Ishan made 25 or more paper balls, which was picked up by the petitioner's father and the respondent on the street, and they were put back. Ishan then picked up stones and started throwing at the respondent. At this point, the petitioner's father lost his cool. Petitioner's father lost his cool, not me. Ishan, I have been kind, but now I will become harsh, stop misbehaving. And all this while, the mother is watching. 45 minutes, she saw all this drama. Then she comes, says something, children go. Leadership can imagine the control of the mother on the children. And this is, if they feel that if they think that they can give me access, they will never give me access. It's only after leadership's order that access started. From 21-12, they think we didn't have any objection with this. We didn't have any objection with this. Why was a single day handing over not done? From 21-12 till 16th of April when leadership passed the order. Not a single day I was given access. And now he says we don't have any objection. It's fine. This is fine. Only overnight is a problem. But why was it not fine before? They should answer this question. Why was it not fine before? Even till date leadership, not a single video call has been given. After leadership intervention 2 weeks ago, I can see my children. Okay, hi, bye. That's it. How can they talk? With a mother standing next to them, they cannot talk. So leadership, this is the problem. And this is a classic case of parental alienation, what is happening. And I will show a judgment on the point when the Karnataka High Court ruled. In the case when the mother is in contempt and adopting such practices, the custody was shifted to the father by the Karnataka High Court. So I will show the judgment, leadership. Thereafter, the petitioner kept enjoying the whole drama from a distance.
No, that I have seen.
That
No,
petition-
point, that is clear, that what you wanted to submit.
Then leadership will also see one table I will only show, which is an annexure one. This is when leadership had given the previous access.
Page number?
Yes. 33 leadership. 31. Now this is the 6 days, the best 6 days of my life, leadership. When I could see my children every day for 8 hours. Where all we went, leadership will see. Nexus Mall, from 10 to 6, 8 hours. Handed over at 10, we went to Kiddo Land, then we went to Electronic City, then we went to a science center, Vega City Mall, food court, science center cafe, Banarghata Wildlife Sanctuary, Butterfly Park, Zoos Kids area, Nexus Mall, Salt Street, Wonderla Amusement Park. All these places I've been with my children for 8 hours. And he says I cannot have overnight access.
Yes.
And children are very happy with me. But obviously, if they come and say in front of the mother, they will say whatever the mother has taught them to say. Or they will say in fear of the mother. Then leadership will see page number 40 I want to show.
40.
Yes. This is leadership, the kind of audacity, I will say, of the petitioner. When there is a video call where leadership has given a direction, it has to be 10 a.m. in the morning. Page 40 leadership has it. I am saying please call when kids are in front of camera. Same way as you expect to do video calls with kids during my visitation. Since April 2003, there have not been any video calls done with the kids. I have simply seen blank sofa or video calls. Today, you took it to another level. You didn't even switch on the camera or video call. And I couldn't even hear kids' voice. Please let me know if this is an acceptable way of doing calls when kids are spending time with me. I am in office Monday and Tuesday, 10 a.m. Can't manage the call. Full stop. And this is her response despite the court order. I cannot do it. And then he says, my learned friend, respectfully, that no, we don't have an objection to this.
Yes.
Then leadership will see the affidavit. This is in response to the affidavit which we have shown what all we have done with the children. Now the new affidavit which they have filed.
No, this is 90, in response to 14.6.
14.6.
You filed 19.6.
Yes.
Then in response to 19.6.
Yes.
You filed 1.7.
Yes, leadership.
Yes. What is relevant in 1.7?
The most relevant thing here is that she has lost a plot completely, I would say, in this affidavit. And why do I say that? Okay, you're talking about adultery, etc., that you keep saying all right. In this affidavit, she is saying, I have forsaken my own mother and I cannot be a good parent. This is the most ridiculous thing that she could have ever said. And she has filed a case of domestic violence, making my mother a party. And she is saying, I forsaken my mother.
What did she say?
Ladyship will see. I'll show the exact line what she's saying. That's why I said they completely lost their plot. Ladyship will see what she's saying about my mother, para 13 of her affidavit.
Dated 1906?
Yes. And I only want to show this because this is the biggest lie they could have said.
Page number?
Page number 6, ladyship. It's para 13. It's page number 7 in the one draft which they have sent.
Seven is one.
No, wait.
Yes, I've seen that 13.
Para 13, ladyship. It is pertinent to reiterate the respondent has forsaken his own mother, failing to provide the care she extended to him till his adult life. Such disregard for familial duties towards his mother casts doubt on his reliability as a custodian for children. Children are bound to observe the parents and adapt the same behavior in wide range of social situations. This opportunistic pattern of behavior towards his mother is now manifesting in his treatment towards me, the mother of the children. Exposing the children further to this behavior through extended visitation overnight stay is detrimental to her long-term emotional.
Where did you answer that?
Ladyship, in my reply.
Yes.
This was. In page 11, ladyship, the contents of para 13 are wrong and denied. Page 11, para 17. It is denied respondent's forsaken his mother, failing to provide the care she extended to him till his adult life. It is denied that such disregard family duties towards his mother cast doubt on his reliability. It is further denied the opposite pattern. It is shocking to note, we'll see after a few lines. It is shocking to note that the petitioner has gone to the extent of stating that the respondent has forsaken his relationship with his mother. The petitioner is the one who has filed false domestic violence case against the mother of the respondent, making her a party to
So
the
where are
case.
you? I'm not able to get that para number?
Paragraph number 17, ladyship. Of
70.
17, ladyship.
Yes.
Para 17, I would say the 8th line from the top. It is shocking to note that the petitioner has gone to the extent of stating that the respondent has forsaken relationship with his mother. The petitioner is the one who has filed a false domestic violence case against the mother of the respondent, making her a party to the case. The petitioner is the one who has dragged the widowed mother of the respondent to the litigation who was 70 years old. The mother of the respondent is currently staying in Kolkata and is looking forward to meeting her grandchildren, and she would be more than happy to come and take care of the grandchildren whenever the visitation rights granted by this honorable court is complied by the petitioner. I've used the word complied. Visitation rights have been given, but compliance. I have tried to speak to my grandmother has tried to speak on video calls. Those photographs are also annexed with my memo. No access. My grandmother was not allowed to speak to the grandchildren. And very interestingly, since this topic has come up, ladyship, on the last visitation on 23rd of July, my daughter tells me that I will only listen to my side of the family, not your side of the family. But then, because in your side of the family, only my grandfather was good, rest nobody is good. Then my client asked him, how do you remember the grandfather? No, I don't remember, but you were only 3 years old when he passed away. No, but she didn't have anything to say. This is the kind of tutoring which is happening. Nobody is good in your family, only your grandfather was no more. And when the daughter was only 3 years old when he passed away, and this is what the mother is tutoring the children to say, that nobody is good in their family. They want to totally disconnect from my side of the family. Absolutely. I also have a sister. I also have cousins. My sister has 2 children. They all love each other. But no, she wants to totally cut off. For what? So that she can settle some scores. She can just show that how vindictive I am. I'll teach him a lesson. That's it. That's the only point. The ladyship thereafter. The interesting point, because I'm seeing this again, this page number 8, what they were trying to harp on. Some Ketan Manik's message which they are showing. Ladyship, I will not even get big A, this, whatever this, this does not have any, it's a A.
Those are not relevant for this.
No, I'll just say one thing. I'm not even relying on this. A, this doesn't have a 65B certificate. B, it shows her again her vindictiveness. She is telling him, hi Ketan, sorry to hear the development. It is hard on the children. You may kindly share anything that can help on so-and-so number or so-and-so email ID, as it may help me in safeguarding children's well-being. This is what she's going to any extent. And when this is happening, when leadership had given the visitation rights, she knew that she's losing the grip on the children. I have to do something. She writes a message to Ketan. Give me something. I'm losing the case. Give me something. This is how vindictive she can get. And this kind of a person will let me see the children.
Yes.
She will not. Over her dead body, she will let me see the children. Thereafter, leadership will see the judgment which I pointed out.
Yes.
This judgment leadership is passed by the Karnataka High Court. We start with.
Take that.
These are all part of the lower court record as well. But
Yes.
leadership, this was a case which I had occasion to argue. Para 15 of this judgment by Justice Nakusani. In this case, leadership, there were several orders of visitation which were repeatedly being flouted by the mother. And in para 15, the court says, a collage of the judgments of the apex court, as extracted herein above, the court has permitted shift of custody of the minor child to the other parent when the other parent has violated orders of court, but holds that in the best interest of the child, the court should pass appropriate orders in light of the aforementioned piquant situation, and bear in mind the interest of the child as also the attitude of the wife in not adhering to the orders of the court. I deem it appropriate to give the following directions. First, the petitioner father shall be entitled to interim custody of the child for 1 month from the date of receipt of the copy of this order, which would be enough for bonhomie for the father with the child. It is important. In this case, also for 2 years, the child was deprived of the father. The court says 1 month, the child should be shifted so that the bond can be created. This direction is rendered only for the reason that the respondent wife is not permitting visitation despite repeated orders and warranting shift of the custody from her shoulder. After 1 month, the concerned court before whom the proceedings are pending in GWC shall interact with the child and then pass appropriate orders. It is made clear that in the event the wife violates the orders passed by the court with regard to visitation, the court would be at liberty to pass appropriate orders in accordance with law, which could even be shifting of custody of the child to the hands of the father. The mother shall be solely responsible in the event court would be constrained to pass such an order. This is the order passed by the Karnataka High Court. Thereafter, this is the judgment which is a binding precedent on the importance of the role of a father. This is very, very appropriate and apt for the case. Leadership will see paragraph number 72. For the boy so young in years, it is basically what the court is deprecating the practice of the mother to be hammering negative things against the father to the mother. For a boy so young in years, these and other expressions suggesting a deep-rooted dislike for the father could arise only because of a constant hammering of negative feeling in him against his father. This approach and attitude on the part of the appellant or her parents, she lives with the parents' issue, can hardly be appreciated. What the appellant ought to appreciate is that the feeding the minor with such dislike and despair for his father does not serve his interest or his growth as a normal child. It is important the minor has his father's care and guidance at this formative and impressionable stage of his life, nor can the role of the father in his upbringing and grooming to face the realities of life be undermined. It is in that view important for the child's healthy growth that we grant to the father visitation rights that will enable the two to stay in touch and share moments of joy, learning, and happiness with each other. So this was a case and they were living in different, but this is the finding of the court, Ruchi Majo. And these judgments were also relied upon in the other High Court case leadership. Thereafter leadership, this is one-page judgment
Take that.
passed by the Supreme Court, which is very clear on the point, which says that whatever be the background of the case, it cannot be so acrimonious so as to deny the right of the father to see his daughter. is basically that however bad a case can be, then leadership, this judgment which leadership has already seen in the impugned order, Yashita Sahu.
It's already extracted. in
It's
the
extracted.
snap
This
and
is extracted. Yes.
It's a seen it. Which para of it?
Leadership in Yashita Sahu, paras 19, 20 and 21, 22. It basically says it's the basic human right of the child. And then courts have to be wary with the allegations because they paint them as villain. That is the finding of Yashita Sahu. Then leadership, this is another judgment which we relied upon in the trial court. This is on the point, which is this, I started with the judgment in the trial court. Because this judgment, the wife tried to say that the husband will sodomize my child.
Which para?
Leadership. Paragraph 6. Several police complaints were filed on this point. And despite that, the court said all this is negative and gave me joint custody of the child. I started with this because I knew all the allegations they will raise before. So I had already shown the judgment at the starting judgment. And it's relied upon, it's not, is reference in the impugned order. Para 6.
Or
Mr. Nagesh Reddy.
That those are all the complaints. And where is the order of the court?
Leadership
Where
is
is the ratio?
yes. The ratio of this case,
Para
leadership,
26.
para 26, because it says a parent cannot be the guest in the life of the child. It is if visitation rights only are granted for limited hours, it may not be sufficient for the child to have comfortable time with the father or mother, whoever the case may be. The wider the gap, the bonds get broken quicker, and the child is left confused and ends up believing this. Such acts of any parent in separating a child from the other parent should be nipped in the bud. Otherwise, the separated parent ends up becoming a guest in the life of the child. Overnight custody must be encouraged
Yes.
wherever possible. And mere meeting and spending time with the parent for a couple of hours in court premises, hotel, theater, mall, park, etc., under the supervision of the other parent or relative will not serve any purpose of visitation, as the child will be under psychological pressure and will not be comfortable. Thereafter, the court also recommends 31 to win over each other. Parents shall not use the child as a pawn against each other. The parents should not poison the mind of the child. These are the findings given in para 31 in this case. This is also relied upon by the trial court. Thereafter, ladyship, there are 3 judgments on the point of adultery. They passed by the Bombay High Court and the Delhi High Court. It will have persuasive value, leadership. He is also relied on in the trial. This leadership, I again had the opportunity to argue this in the Supreme Court. The interesting point in this case is that the mother had at least 6 reported adulterous relationships, and she was called a nymphomaniac in the petition. And in this case, again, the court said this is all matter of trial. It cannot be decided here. And this was a case of a custody of an 8-year-old daughter. This particular case, then who became 9 years thereafter. But in this particular case, the court in paragraph 45, leadership will see. The submission made on behalf of the petitioner husband as regards the adulterous behavior of the respondent wife, according to me, these are the allegations which are made in the marriage petition by the husband before family court filed in the year 2020. The said allegation has to be proved by leading evidence of the family court. Therefore, based on the allegations, the doubt as to whether the custody can be given to the wife will have no bearing. There is no doubt as held by the various judgments that not a good wife is not necessarily that she's not.
Para number?
45, leadership. 45. And then it relies on a Delhi High Court judgment, this judgment itself. In the present case, regards the allegations made by husband are still not yet to be proved. In the judgment of Vineet Gupta versus Mukta Agarwal, Delhi High Court, it has been held that even though the allegations are proved as regards the wife's extramarital affair, still, as far as the custody of the minor children are concerned, in a given case, same can be granted to the wife. In this case, it was a step further, even it's proved. So they are trying to paint their entire case on the point that they have already proved, and I am denying it again and again and again. They're saying, no, we've already proved it, and as such, we won't allow it. Similar judgment leadership of Ratnamala. This was again part of the lower court record, in which the court again said in para 17.
Yes. Yes.
Para 17 leadership of the judgment, which the court deprecated the practice of trial court, which had proceeded on the basis without going through the evidence and saying that the mother was adulterous and denied visitation. That order was overturned. Another fact for which definitely objection will have to be taken in respect of the observation para 66 of the impugned judgment, which are in respect of allegation of adultery. It appears that the opponent had produced on record the transcription of the mobile conversation between the applicant and the said person, and the copies of their photos showing closeness along with his affidavit. That evidence has been considered by the learned trial judge without it was proved in all legal aspects. For the mobile conversation, it appears as is absolutely no discussion. There was no mandatory certificate 65B. So also as regards the photos are concerned, it appears that the concerned photographer was not examined and these documents have not been separately exhibited. There was no opportunity for the wife to cross-examine the husband, and therefore though the fact of adultery is alleged and it has not been proved by cogent and conclusive evidence by the husband, the trial judge ought not to have considered it for a sentence also. Further, in paragraph number 68, the learned judge went on to observe that those allegations regarding relationship of the wife and the said person were not without foundation or reckless. That was a factor which has been taken by him for considering deciding the custody of the children. This is totally illegal. When the full-fledged evidence was not laid, the court had not come to the conclusion that the allegations of adultery are proved merely because some documents have been produced.
Yes.
So this is the judgment. And the third, or Delhi High Court, which edition I've already pointed out, but I'll also give a copy.
Para number.
Para 27. The evidence on record reflects that the respondent mother frequently spent her time by taking leave from the office or otherwise with a third person, so-and-so, in whom she had special interest. While the overemphasis of the entire evidence has been to prove the extramarital affair, but there is not an iota of evidence to show that whatever may have been the personal affairs of the respondent mother, she in any way failed to take care of the needs of the children. The respondent mother may not have been a faithful or a good wife to the appellant husband, but that in itself is not sufficient to conclude that she is unfit to have the custody of the minor children, especially when no evidence has been brought on record to prove that she in any manner neglected to take care of the children or that her conduct has resulted in bad influence of any kind on the children. Now, Ladyship, when I started with the matter, I shown some photographs of how the children had spent time with me even before the drama unfolded. So, Ladyship, those pictures have to be seen. They were the pictures before the litigations even started.
Yes.
Now, those are the pictures which have to be seen, how happy the children have been with me. They're playing with me, dancing with me, and all those pictures are descriptive. If Ladyship wants, I can just quickly go through those page numbers of those pictures in my memo. If
One photographs.
yeah, I've already,
No, that I've seen.
Ladyship seen that.
Yeah.
And then Ladyship, in one picture, it was also seen that the mother was also having alcohol with the father together. And she's saying, and then there was an expression used by the mother before the trial court that I was sloshed earlier. This is before the court. When my learned friend was not there, some other counsel was there. She made a statement in the court. So Ladyship, the point is people throwing stones on a glass. They have to see. It's not drinking socially. She's also drinking. Then she's saying, I used to get sloshed before, but now I don't get sloshed. Ladyship, the fact of the matter, this is love marriage. They have been married since 2012. Now, she stayed in Bombay since the time they got married. The minute the custody case was filed, she orchestrated a transfer from Bombay to Bangalore so that she can deprive the father of the children and teach him a lesson. I rest my case. My rate is also there, Ladyship, which my prayer clause is only on the point that I should have weekend access. And because of parental alienation, I need a substantial access for Dashera, Diwali, and...
He was saying about the festivals. What are the festivals?
Now, Ladyship, for one thing I agree with my learned friend of all the things he said, that yes, Diwali is the most important. Diwali is the most important festival. This I agree with him. But having said that, the children have Dashera break in school, and that is one vacation. But I have very sure lost 10 days in the summer
Festival,
vacation.
Word used is.
Summer
festival.
vacation, I only had.
Modified and a
Because-
different
yes,
order
yes.
is passed.
But leadership, I should be
Yes.
compensated for that leadership because I should be
No,
compensated.
no, let's go to that page. So, no, as far as the important festivals are concerned, no, we'll be restricting it to Diwali. Diwali.
Look, Diwali, Holi, Diwali is then even Christmas, because it's my son's birthday on Christmas.
No, birthday is a
25th.
different one. Festival, anyhow, you will have that son's birthday also. So now don't include Christmas. You will have it anyhow.
No, his birthday and Christmas continues.
Continue.
But any major festival, leadership should be a major festival, Holi, Diwali, Christmas. If there's something else, leadership, which,
That will specify. That's why I'm asking.
yes,
you.
yes, we'll just, even Dashera vacations, leadership is a vacation.
It is vacation, my lord. That is, Dasara is a vacation. Dasara is a vacation. The festival,
Then there is Rakhi leadership. Rakhi is also
my
a
lord,
festival.
that is umpteen number of things can be said. But what is to be seen is what is the festival for Hindus. Diwali is the festival which I would submit. And all this is brought in now, not earlier. While in the trial court also, I have instruction to say so.
No, court says
Festival.
on all major festivals.
My lord, a major festival is Diwali for Hindus.
Why Rakhi is not a major.
Rakhi
festival for the-
Rakhi is a holiday. It is not celebrated as a festival. It is a holiday. Rakhi is a holiday on which Bandhan is tied. Rakhi is tied. That is, kindly consider this, my lord. I am not. Yes, and my lord, I have something to say. I did not open my mouth when he said, he used a word that sodomize. Even they may say, nowhere in the affidavit it has come. I have not, my lord.
I'm not saying.
I have not said it. I will not say it. Why did that expression used now? I have strong objection for this word being used by the other side. My lord, the children may not know what it is. They don't know. Why infuse all that which is not there on record, not said, only to satisfy himself that he can get away with this, get in custody of the children.
Diwali, Rakhi and Dasara.
But Dashera, the vacation leadership, because Dashera vacations will be in the school vacations, which are at least, and winter vacation leadership.
My
Well,
lord,
vacations
those
also have to
are
be given.
winter vacation is again Christmas vacation. We don't know, we don't have the children's curriculum, all this.
No, winter vacations happen for all children. Because I've missed out on summer
No,
vacation, I
My
should
lord,
get full
in
winter vacation.
Karnataka, I can say that winter vacation happens in some schools only for a day. I can get the details.
If that is what, then he'll not have. If
Yes.
they have,
But
he'll have.
my lord, this is done with the idea to extend the visitation rights or custody. Kindly see how he is proceeding with it.
No, please understand one point.
Please.
It is not that he is asking something which is not justified to ask.
My lord, my lord,
They have every right to ask for it. Mother cannot complain that he's asking that, he's asking this.
My
That's
lord,
his right to have it. It's for the court whether to grant or not, and you have
Yes,
every right to
yes.
say
In the
that why
welfare-
it shouldn't be granted.
No, it is
No.
with the court. In the welfare of the children, having regard to these incidents, which has been placed before the court, my lord, it is not something which a mother cannot ask. She is placing all this material before the court because it is not safe to send the children with the father. My lord, I have one more thing, one citation to place before the court.
Yeah.
That is that is AR 2024 Supreme Court 1299 at paragraph, the principles, paragraph 13.
Yes.
Correct. Left hand side. In Neil Ratan Kundu and another versus Abhijit Kundu, this court laid down the principles governing custody of minor children and held that welfare of the children is to be seen and not the rights of the parties by observing as under principle governing in our judgment, the law relating to custody of a child is a fairly settled, and it is this. In deciding a difficult and complex question as to custody of minor, a court of law should keep in mind relevant statutes and the rights flowing therefrom. But such cases cannot be decided solely by interpreting legal provisions. It is a humane problem, and it is required to be solved with the human touch. A court, while dealing with the custody cases, is neither bound by statutes nor by strict rules of evidence or procedure nor by precedents. In selecting proper guardian of a minor, the paramount consideration should be the welfare and well-being of the child. In selecting a guardian, the court is exercising parents' patria jurisdiction and is expected, nay bound, to give due weight to a child's ordinary comfort, contentment, health, education, intellectual development, and favorable surroundings. But over and above physical comforts, both moral and ethical values cannot be ignored. They are equally, or we may say even more important, essential and indispensable considerations. If the minor is old enough to form an intelligent preference or judgment, the court must consider such preference as well, though the final decision should rest with the court as to what is conducive to the welfare of the minor. Pausing here for a minute, my lord, your lordship had that occasion to see both the children, how they behave and what was their expression. And the son also expressed that the conduct of the respondent, behavior of the respondent was not proper. That was expressed to the court at one instance. Now, we are unable to appreciate the approach of the courts below. This court in Catena of Decisions has held that the controlling considerations governing the custody of children is the welfare of children and not the right of their parents. Kindly come to paragraph 15. This court in Roxanne Sharma versus Arun Sharma opined that child is not a chattel or ball, that it is bounced to and fro. Welfare of the child is the focal point. My lord, the welfare of the child is the focal point.
Yes.
And one more submission is, my lord, the transfer certificate of the children is still with the respondent. He refuses to give the certificates. And the school is demanding the certificates to be given.
Now, Leadership, I'll argue on this point very briefly. Firstly, I have no access to any school records, their report cards.
That's a
Now,
different.
Leadership, the point is this matter even was raised in the Supreme Court.
Is pending, GNWC is pending before the court, and that would be decided. As long as the child is here and joined in school studying admittedly, for any other extraneous reasons, you can't withhold that.
Leadership, the fact of the matter is that we have filed a GWC for shifting of custody. But Leadership, the fact of the matter is that I am willing to do that, Leadership. There's no objection. I'm only saying that I should have access to the school records,
That
parent
will be-
teacher.
no,
That's also in my prayer, Leadership.
Everything will not be decided. now.
Leadership, that is
Your
also in my
GNWC
prayer.
there, And that is nobody's plea before the court. But you
It's my
can't,
plea before the court, Leadership. In
what
my,
did you say?
I'm saying I should have the records of the children. Their mark sheets, their attendance sheets, I know nothing. The fact of the matter is the parent teacher
No,
meeting.
that we will see, but
But Leadership,
you have to give all the records pertaining to the
Leadership,
children,
this
which have to be submitted to the court.
this transfer certificate, Leadership, what they're trying to talk about. For 2 years, they're saying that the child does not have the transfer certificate. He's studying in the school. Had it been such an important issue, where is an application made for this? In any court?
There is an application.
I'm sorry. The thing is that you are raising this point for the first time now. Now, the fact of the matter is,
Then the problem is.
I'm just saying, this is a non-issue. It's a non-issue, nothing else.
Want to fight on that again?
No, I don't want to fight. I only want to say,
Very simple issue.
Leadership,
All the time, not talking about the rights of the father. Its duties are also. This is
Leadership,
one
I
of it.
agree.
Don't give any kind of embarrassment to your children before the school.
Leadership,
Asking for, because it's a basic requirement, they need to have the TC. What
leadership,
will you have it by holding it?
I'm not saying that. There's no discomfort caused.
Is it
caused
like, I'll
children.
give the TC provided you do this?
No. I'm not saying that.
First, you should do it. What you want, you can ask the court. That's it.
Leadership, if leadership so deems it fit, I will deposit it. No problem.
Please
but-
come.
Now, there is one judgment I want to point out in response to what he just said, because he showed a judgment of Justice.
No. A reply to reply.
No,
Again,
this is
reply
a
to
very,
reply will
because
not
this is
go on.
exactly on the same point by the same judge of the Supreme Court, which is why it's important.
My lord, if that is so, I have
This-
something more to read out
this
of
is a
it. I
judgment.
don't
Justice-
want to trouble the court at this.
Justice C.T. Ravi
yes.
Kumar's judgment, when he says a 9-year-old child said that they want to be with a particular parent, and Justice C.T. Kumar said, no, I will not listen to you. I will decide what is in the best interest and I will
Agreed
not
with
listen
the
to you.
Order passed.
So for
with
maintenance
of-
for the children is not given, madam.
number
Nothing is given
402
to
of
the children.
2022. Agreed with the order passed in I number 3, in MC number 402 of 2022, dated 21st December 2023, both the father and mother are before this court. The father's writ petition is numbered as WP 9, the mother's writ petition is numbered as WP 9885 of 2024, and the father's writ petition is numbered as WP number 11842 of 2024.
I may be excused for 5 minutes.
Yes, the respondent, the mother, not the respondent, the mother had filed MC number 402 of 2023. Seeking divorce.
Oh, 40 of 22, my lords.
402 of 2022, seeking divorce. In that, an application is filed, that is I number 3, by the husband, praying for interim visitation rights in respect to the minor children who are a boy and a girl who are aged 9 years and 7 years respectively. The reliefs that are sought by the father are below as follows, page number 115. I have marked it in the bold portion that you extract. The mother has filed her objections. Wherein, not before her objections, it is a case of the father that he had filed a GNWC petition numbered as D10/2022 before the courts at Bangalore.
No, it was filed before the courts at Mumbai. Later it was transferred to Bangalore.
At Mumbai.
That's right, Leadership.
And later the same was transferred to Bangalore and numbered as,
Well, he has the number. Notice is not being
Have the
served
number?
upon us. We don't see
No,
number.
357 of 23.
Huh?
MC number 357 of 23.
357.
357 of 2023.
Yes, madam.
It is stated that the husband had filed a petition before the apex court to transfer the petition filed by the wife to the family court in Mumbai. The wife had also approached the Honorable Apex Court seeking transfer of the GNWC petition filed by the husband at Mumbai to Bangalore. Both the petitions were disposed of, whereby the petition filed by the wife is allowed and the GNWC pending at Bangalore, at Mumbai is transferred to the courts at Bangalore. And the Apex Court had granted the access to the father through video conference on Saturday and Sunday at 4 p.m. for minimum period of 30 minutes, subject to extension mutually between the wife and husband. It is a grievance of the husband that, of the father that, in spite of a specific order from the Apex Court, he was not allowed to communicate with both the children. And the order of the Apex Court was not complied with. As such, he has come up with this present application. Next para. The wife had filed her objections. Not wife, wherever you refer it as for the father and mother. The mother had filed her objections. Stating that the husband is addicted to drinking, poker games, dance, bars, assaults, drugs, and lying to family of his bad vices, as well as violent and accuses of violent behavior. And if the weekend rights are granted, it would affect the extracurricular activities of the children. It is stated that the respondent is of despicable behavior, and if he is permitted visitation rights on major festivals, it is not conducive to celebrate such festival. It is also the case of the mother that the children do not dislike the father and they do not like to go to him. It is a case that she is in a better position to give better education to the children. And even during her stay at Mumbai, she was taking the responsibility of the children. It is also alleged that he is having extramarital affairs. And it is not good for the children to have any access with the father. The court below, while passing the order, had taken note of the order passed by the Honorable Apex Court, and also the fact that the allegations are leveled against, leveled by both of them, while allegations leveled by both of them and the court, relying on the judgment of Ashita Sahu versus State of Rajasthan and others, has observed that, as per the said decision, that the child is a victim in custody battles, though the parents otherwise love their children, portrait the picture as if the other spouse is villain and he or she alone entitled for custody of the child. The court also observed that in the said judgment, it is held that a child requires at a tender age the love, affection, company, protection of both parents. And this is not only the requirement of the child, but it is a basic human right. And the court, by applying the said ratio in the above judgments, had passed the following order. Page 127, the order is there that you extract. This matter has come up before this court when this matter came up before this court on 16/4/2024, this court has passed the following order. Extract that order. Thereafter, on 25/4/2024, another order is passed by this court. Extract that also. And thereafter, another order came to be passed on 14/6/2024, and that we need not extract. 14/6/2024 and 19/6/2024, where the father was latest order on 19/6/2024, whereby the father was permitted to exercise the visitation right on 23/6/2024 and 36/2024 between 10 AM to 3 PM. And also a video call on Saturday and Sunday between 10 AM and 10:30 PM. And today, the matter is taken up for final disposal. After an affidavit is filed by the mother on 14/6/2024 and 19/6/2024. Huh?
Correct.
In the affidavit that is filed on where is that 14/6/1? 14/6. There any other grounds? It is here. In the affidavit filed on 14/6/2021. I mean, sorry, 14/6/2024, it is stated that on 11/5/2024, when she took the children to the agreed location, it is stated that as the children were not, in spite of her request, were not getting down from the car, the father shouted and made allegations against her. And because of this attitude, the children are not interested to meet him. And it has affected the psychological behavior of the children, creating fear in their minds and mistrust due to this constant fighting. And she has made, it is stated that the visitation that had taken place was not smooth and congenial for the children. It is stated that he had multiple conversation, father had multiple conversation with the child, with the children. And there is no, the approach of the father is not responsible and wantonly lavishing them with junk food, limitless games at video arcades, amusement parks, and talking to them about meals at five-star hotels. He's consciously creating a bias on financial status with statements like, within inverted commas, purchase enter Wonderlaw for you, which is impacting the children adversely. It is stated that the children are complaining about stomachache as they are not taking adequate water and avoid going to the washrooms, untimely meals. They're complaining about several issues. And also it is stated that the father is not timely returning the kids as per the order. And during the visitation, though this court has directed the mother to have access through audio and video calls, the father is not permitting. And she has narrated an incident where the daughter was sent to the public washroom unsupervised. And certain, the prescriptions where the children were taken to the hospital were filed. Then another affidavit came to be filed on 19/6/2024. Wherein it is stated that both the children are minor and are of impressionable age. It is a case that the father has exposed them to his extramarital adulterous relationship and they are used as pawns to further his interest. It is stated that the children have been introduced to the adulterous partner as naive mummy within inverted commas or new mother that is distressing and unacceptable for the emotional well-being of the children. She has also mentioned about a WhatsApp conversation with one Mr. Ketan Manek, who is the husband of a woman with whom her husband is allegedly having a adulterous relationship. It is also stated that about his conversation with an individual named Sweetie, which shows that he is continuing in adulterous relationship. He has made allegation. It is stated that the petitioner has not taken care of the children and never behaved like a good father. And he's also making comments against the mother, which has also affected the children, and they are not interested to see him. An allegation is also made about the husband not taking care of, the father not taking care of his mother. And this kind of behavior from the father will also have an impact on the children's future. It is stated that the now schools have resumed. They've also, the children have some assignments during the weekends. They also expressed a desire to spend time during weekends with the neighborhood friends. In view of the court orders, they feel embarrassed to explain their absence to their friends. Will stop. Extending the visitation to overnight stay will further adversely impact both their studies and their ability to develop healthy social interactions with their peers. As such, it is stated, and it is stated that being a mother, a duty is cast upon her to look after the welfare of the children. And she is duty bound not to consent for the overnight custody of the children. Along with that, she has filed the WhatsApp conversation between her and one Ketan Manek and the conversation between her and the husband. And also how many times she called while they were in when they were in visitation, and how many times they spoke, and how many times she couldn't speak to them. Then she also gave a table about the video calls and what had happened. To this, a reply was filed, for both, two replies were filed. For 14/6/2024 affidavit, a reply dated 19/6/2024 is filed. And for an affidavit filed on 19/6/2024, not reply objections so dated 1/7/2024, filed by the father. In the first reply dated objections dated 19/6/2024, it is stated that whenever the visitation takes place, when the mother is around, the behavior of the children is altogether different. Once the mother leaves the place, they're very playful with the father. It is the case of the father that because of the bonding between between the children and the father, the mother is becoming very insecure. And she wants to, and as she demanded an amount of rupees 10 crores in the maintenance proceedings, she's using the kids as pawns. And she has no concern for the psychological well-being of the children. And this amounts to parental alienation. It is this case that the children are taught to tell their names as Ishan Prabhakaran and Arya Prabhakaran when their names are no, insert, don't write the names. The children are Prabhakaran is her father's name.
Yes, that is the wife's name. Wife's son.
Wife's father's name. The children are given the name of the maternal grandfather instead of the father's name. It is stated that, and he has given the list of dates and what has transpired on those visitation rights. This is from page 9 till page 14, all that you extract. It is stated that everything went on well. And he had taken utmost care of the children and and even the food, what they have taken is also, even on that aspect also, he had taken utmost care. Where is that, you said
Yes,
something?
I've annexed the invoices, the
No,
document.
no, no.
Page 36.
Some other days you've given at some other place. Page number 31. Oh.
Yes, yes, yes.
Then-
Vegetation.
Then he has also filed before this court about the itinerary of visitation between 17/4/2024 to 22/4/2024, page number 31. Extract that. And also the invoices are filed to show that what is the food he has he fed the children during the visitation. And also a WhatsApp communication between the petitioner and the mother, between the mother and the father, wherein when he mentioned about the court order and the video call, it is the response of the mother is she is in office and Monday and Tuesday 10 a.m. she can't manage the call. Then in the reply, in the objection stated 1/7/2024, denying all the extramarital affairs and other things as stated by the wife. It is stated that in fact, the mother is using the children as pawns. All the statements about the made with regard to the adulterous partner and or denied. And these cannot be considered by this court in these proceedings. All these allegations about allegations of adultery and all these wild allegations are made only to deny the father the overnight custody. It is stated that the father has always been cooperating was taking care of the children. It is stated that in one para, in the affidavit, it is stated that he was not taking care of his mother. And because of that, and it would have an impact on the children also, as they would learn from the father. It is stated that in fact, the mother has filed a domestic violence case against the mother-in-law. And that statement that goes contrary to the statement that is made before this court on oath. It is stated that he could not exercise in spite of the orders passed by the court on several occasions. He could not have the video call with the children, and the mother is not cooperative. Learned counsel appearing for the father submits that, mother submits that the father can exercise the alternative weekend visitation rights granted by the court.
That is only from 2 to 6 p.m. on Sundays. Yes.
What has been granted is that
Yeah.
alternative weekend.
Yes.
The alternative weekend visitation rights between 2 to 6 granted by the trial court can be exercised. And even on festival days also, they have no objection. But when it comes to the vacation and the overnight custody of the children are concerned, concerning the conduct and the adulterous life he is living, it would not be congenial for the children to stay overnight with the father. It is stated that while granting the visitation rights, it is not only the right of the father, but ultimately the court has to look at the welfare of the child. When the wife had filed several documents to show the conduct of the husband, all that speaks volumes about his character. And if the children are given overnight custody, the impact of it on their lives, or at a very tender age of 9 and 7. It is stated that except for the court orders and as a mother was pushing them to meet the father, they are not interested to meet the father because of his behavior. And it is stated that the father is very rude to the children. He had relied on the judgment of the apex court in case of Shahjah Aman Khan and another versus State of Odisha and others, reported in 2024, SC 1299. He had relied on para 13 of the said judgment, which reads thus: in this para 13 and 16 months, 14, 15, 16,
18, 19 and 20.
20, 19 and 20. Please extract that. Relying on these judgments, then counsel submits that while granting the visitation rights, the court is not bound by any statutes, but ultimate consideration should be the welfare of the child. Next part. Welfare of the child, and it is submitted that the mother is not, she filed a specific affidavit before this court that as far as the overnight custody, it is not good for the welfare of the minors. Next. Then counsel appearing for the husband, for the father, submits that by giving by narrating the manner in which the visitation rights have taken place pursuant to the order passed by this court. It could be established before the court that the father was having a good bonding with the mother, with the children. It is submitted that in all those visitation rights that were exercised, what the father could feel is like the mother is the children are constantly tutored, and on every day of visitation, it is taking some time for them to settle and to come out of the said tutoring of the mother. It is submitted that the mother has insecurity, has developed a sense of insecurity as the kids are being very much attached to the father. He submits that all the kind of the wild allegations that are leveled by the mother cannot be taken into consideration at this stage, as all these allegations are made only to deprive the father to have the overnight custody of the children and to prejudice the mind of the court. It is submitted that all these allegations are subject to proof, and the same would be decided by the court below. He submits that at this stage, this is not the appropriate stage where this court can consider all those the allegations. He submits that she has filed a WhatsApp conversation, referring to one, what is his name?
Ketan Manik.
Ketan Manik, wherein she asked him to give all the details about the conduct of the father. Then counsel submits that the whole endeavor of the wife is to collect collect the information so that can be placed before the court and the father be deprived of his right to visitation. He submits that whatever is the conduct of the either of the parties, and whatever is the adulterous life as put forth by the wife, still the several courts have taken the view that just because a person is having adulterous, living in adulterous life, that cannot be a ground to come to the conclusion that she or he is not a good mother or a good father, and they cannot take care of the children. He had relied on the judgment of the Delhi High Court, a Bombay High Court. You relied on Delhi also in this regard?
Yes, one Delhi and two Bombay.
These are two Bombay. Where is Delhi?
Delhi.
Delhi is, what is the name, party's name?
Abhishek. It is Vineet Gupta versus Mukta Agarwal, 2024. SEC.
Vineet Gupta, Delhi High Court?
Yes. Versus Mukta Agarwal. Yes.
He had relied on judgment of the he relied on the judgment of the Bombay High Court in case of Abhishek Ajit Chavan versus Gauri Abhishek Chavan, arising out of WP number 4060 of 2024. Relying on the said judgment. Which para you relied on?
Yes, this is para 45.
Is relied on para
5
relied on para 45
and 46.
this said judgment 45 and 46.
And by the way, this has been upheld by the Supreme Court. This has been upheld by the Supreme Court. It was
45,
challenged but
46.
dismissed.
It's trial. Yes, relied on the para number 45 and 46 and submits that cannot be a ground to deny the visitation rights to the father. He submits that this judgment of the Bombay High Court is upheld by the Honorable Apex Court. He relied on para 45 and 46, extract 45 and 46. Then he had also relied on the judgment of the Delhi High Court in this regard. That is in case of Vineet Gupta versus Mukta Agarwal, reported in 2024, SCC Online Delhi 678, para number 27.
27.
Extract para 27 of this judgment. We had relied on another judgment of the Bombay High Court in case of Ratnamala versus Panduranga Uday Jate, Jad 80, 2021, SCC Online Bombay 12437, para number 12.
17, Your Worship.
Para number 17. 17. Extract para 17.
And 21 also.
17 and 21. It is submitted that the court, while granting the custody or the visitation rights, have to look at the welfare of the child. And just because they're residing with the mother and where there is every scope for tutoring by her. And basing on that, on the ground that the children are not interested to meet the father, if the father is not granted the visitation rights, it amounts to parental alienation. It is submitted that if the father is not given the overnight custody, it would be very difficult for him to develop bonding with the kids. The consideration for granting the custody or the visitation, he had relied on the judgment of the Apex Court in case of Ruchi Maju versus Sanjeev Maju, reported in 2011 6 SCC 479, para 72.
And 73.
Extract para 72. He had relied on another judgment of the Apex Court in case of Ishita Sahu, which was also considered by the court below.
Yes, it was considered.
Ishita Sahu versus State of Rajasthan and others, reported in 2023 SCC 67, para 19, 20, 21, 22. He had relied on another judgment of the Karnataka High Court in case of D. Jabhar versus Mrs. Priya Jose Joshua in arising out of WP number 20190 of 2022, dated 28th June 2023, wherein this court had considered all the judgments of the Apex Court in Gaurav Nagpal's case, Ishita Sahu's case,
And this is Ekta Giri, is MFA. There's another one MFA number, but that can be left.
It is repetition.
Yes, that's fine.
Repetition.
No, there is one more judgment, MFA number.
MFA number and MFA number 2786 of 2022. And wherein this court had passed an order in case where the wife was not adhering to the orders of the court. Where the father was given the interim custody for 1 month for 1 month. and then directed the court below, the trial court, to interact with the child and then pass appropriate orders. Further, court made it very clear that in the event the wife violates the order passed by the court with regard to visitation, and the court would be at liberty to pass appropriate orders in accordance with law, which would even be shifting of custody of the child to the hands of the father. And the mother shall be solely responsible in the event court would get constrained to pass such order. Basing on these, land council submits that in this case, the interaction that went on between the parties, between the children and the father, shows that there is bonding, but for the interference or the tutoring of the mother, and as such, he should be given overnight custody to the child, and also, as he could not have the custody, or he could not have the half of the vacation, though he was having visitation, right, but not the custody for half of the vacation, the same needs to be compensated. And on all the major festivals, the children birthdays, and also in the ensuing Dasra and winter vacation, he need to have half of the half of the children's vacation.
We ask for the full vacation because for the bonding, my prayer is full for entire
If you
Dashera.
take
It's only
a
10
full-
days.
If you
I-
have full vacation,
The-
what would the mother do?
The only reason because I'm not bonded with the child. I need some sufficient. That's my reason. Leadership.
Yes, yes.
My
his
prayer is that.
submission is
Ah,
to have bonding.
yes.
He should have the full vacation.
Yeah, my submission is.
That's what I mean. He should have the full vacation as on all the vacations, the father should have the
No, Dashera and winter.
Dasara and winter vacation, he should have the full custody of the children. Next part. That's
That
his
is my
submission.
submission, sir.
His submission. Having heard the land counsel for the petitioner peruse the entire material on record. This is the case where before all these proceedings were initiated, parties were staying at Mumbai, and mother came to Bangalore and she filed a MC seeking divorce. Father had instituted a GNWC in Bombay. Later, on the transfer petitions filed by both of them, and with the orders passed by the Honorable Apex Court, now both the matters have landed up in Family Court, Bangalore. In that, the present IA is filed. In that, the present impugned order is passed, basing on the application filed by the father seeking the visitation rights and also the interim custody of the minor children who are 9 and 7 respectively. This court to balance the interest of both the parties and also considering the welfare of the minors, which is paramount. This court had interacted with the children, the father, and the mother. And time to time, several orders were passed. In the preceding paragraphs, how that visitation had gone was spent. The mother has her story to put forth, and the father has his story to put forth. According to the father, it went on very well, except for on few occasions because of the tutoring of the mother. And according to the mother, it was never good, and the children were not comfortable. And because the manner in which the father was taking care of the children during that brief period, they were constantly were ill, and she had to take them to the hospital. The main thrust of the arguments of the land counsel for the petitioner and the affidavits that are filed and the photographs that are filed by the wife is she's making the allegations against the father on father that he has all the bad vices, is about his adulterous life, and for that several documents are filed. And looking at that, initially this court has passed an order, later came to be modified at a different, later came to be modified, which are extracted in the preceding paragraphs. As far as the allegations that are leveled against the father are concerned, in the considered opinion of this court, this is not the forum where this court can go into those disputed questions of fact. It has to be dealt with by the court appropriately at an appropriate time. Now, we are on an application for the grant of visitation rights to the father. The manner in which the visitation rights grant on and the interaction of this court with the children and the time to time the orders passed by this court. This court has no doubt in holding that, in observing that the granting of visitation rights to the father is not detrimental to the interest of the children. It is very unfortunate that both of them, both the wife and husband are fighting these battles, and both want to settle their scores. Whereas in this case, the husband on the last occasion when the matter came up, he wanted he said the wife wanted divorce. He's ready to give the divorce, and whatever the terms of the compromise or whatever the terms of the settlement, he's ready and willing, and he'll come up with, is ready and willing. It is submitted by the learned counsel for the petitioner, wife, the mother, that the mother do not want any kind of settlement and she want to fight it out before the trial court on the merits of it. Because of the disputes between the parties, it appears that the wife is emotionally affected. And with all this, she is of the view that the children being with the father is not in their interest. With the disputes between them, it is quite common from her point of view to put forth these kind of the arguments or the perspective to look at the things. But while this court exercising the parent patriarch jurisdiction, the court has to look at the wider aspect and the welfare of the child. The children should not be brought between these battles. Whatever they have the differences, they should settle the same with whatever means and the mechanism they have within the four corners of law. And as far as the kids are concerned, they have the human right and the necessity to have the basic necessity to have the love and affection of both the children.
Parents.
And this kind of visitation rights, which are exercised between a particular period of time, as rightly put forth by the respondent, by the father, as the children are staying altogether with completely with the mother, and the manner in which the allegations that are made against the father and whatever that has transpired, which this court is not going into any of those aspects, she would definitely have her story story. And generally, as the same things will go on in the house, those discussions would have also an impact on the children. As this court had granted the overnight, the visitation and the manner in which it went on, in the considered opinion of this court, the father can actually is entitled to have the overnight custody, but that should be exercised in Bangalore till further orders that are going to be passed by the family court. Considering all these aspects, the order passed by the family court is modified as below. One. The father can exercise the overnight custody on every second and fourth Sunday. Fourth Sunday. He shall pick up the children on on a Saturday evening at 7 o'clock and drop them back at 7 o'clock on Sunday evening. When it comes to the vacation, both the mother and father shall have the equal custody of the children.
There should be mentioned
Summer
first.
vacation, Dasara vacation, and the winter vacation. Next, the father is entitled to have access to the children through video conference for 30 minutes. That is the first point. That should be exercised first. Should be exercised only in Bangalore. First one, point number one. Next, the respondent father is entitled to have access to the children through video conference for 30 minutes on Saturdays and Sundays at 4 p.m. The father is entitled to have the visitation rights to children from 5 p.m. to 7 p.m. on major festivals like Diwali, Rakhi, Dasra, and birthdays of both the children.
They should put Holi also.
Huh?
Holi.
Holy. The petitioner and respondent, the fifth here adds this, the petitioner and respondent shall not force or create any situation which would cause embarrassment to both the children during the children, that's it.
Custody is taken. He should inform the mother that he is
Hmm.
taking the children. And
The
this
one
is-
minute, whenever while exercising the visitation, exercising the custody, the father shall inform the mother the whereabouts or your complete itinerary with regard to where are you, and in those days she is entitled for the children are entitled to speak to the mother thrice a day. Thrice a day.
They should, that's fine, because last time video calls were 10 minutes. That's fine. We don't have an objection.
Thrice a day,
Huh.
audio, video call. Or thrice a day, what her choice, either video call or
He goes for work at 9:30 in the morning. He comes back by 5 or
no, I'm referring to this video call
Yes,
when they are in his custody.
yes.
When the children are in his custody,
Yes.
in the day, she can have a video call, audio call, whatever is her choice, 3 times. That's what I'm mentioning. Then with regard to that video call, when is it convenient? 4 o'clock to 4:30.
4 to 4:30 on Saturday.
Evening,
Evening.
Sunday, 4 to 4:30.
Saturday and Sunday, Ladyship.
Ah.
It was Saturday and Sunday from Supreme Court time. Every time it was.
Whatever
Saturday.
is the Supreme Court order, that's there,
Supreme Court
Saturday and
started-
Sunday, 4 to 4:30. That video call, no, initially 4 to 4.
And Ladyship, when the vacation, can it be defined that first half will be the father, second half will be the mother? Because again, there'll be confusion.
I have something to say.
First half and
Yes.
Customary is on every Sunday.
Saturday and Sunday.
No, it is
Saturday,
second and fourth.
Second and fourth.
Second and fourth Sunday, that is
Overnight. yeah.
overnight. The Saturday evening they'll pick up, Sunday evening he'll drop. Overnight custody is having. That I clarified.
After July 15th, because children have exam till 15th of July.
They should.
That is whenever, 1 minute, whenever the children's exams are there.
Ladyship, my
Ladies,
humble
that has
submission,
to be
I will
fixed.
teach the children. I can also teach the children.
Suddenly, how will you teach?
No,
children?
Ladyship, my only submission is that if
One more thing, the father shall hand over the TC and other school records of the children while they were studying in Bombay school records.
And Ladyship may give me the liberty to write to the school to add me as a parent in their circulars. Because they should not. No, I can, I as a parent can add myself because as the mailing list, I should be informed about their activities.
Father has every right
Yes.
to be part of.
How can you stop me to know my children?
1 minute, let him say, you can respond. Yes.
Because the school authorities also will ask for permission and he will start writing to the school. All this.
I need to know my mark sheets.
Actually, his permission is not required. He will
Yes.
only know. He will know, not for each and everything now, please understand this. As of now, they are in her custody.
Correct.
Until your custody, no, either of you, no, both of you are at loggerheads. No, for everything, both of your concurrence is required. It's very difficult.
No, I'm not telling
I'll make it
concurrence.
very clear that father will have the access to know about their what is going on with their school. But ultimately, it is the mother who will deal with the school. Both of you can't.
If there's a parent-teacher meeting, I can't go.
You
As-
can go, but
That's
you can't tell anything to whatever ultimately it is no, that is.
I'm only saying
that's
I
not
should
stupid.
have access.
You
They
just want
should-
to know.
Yes,
That's it.
I want.
The father can have access to the children's school, access to the school. How do you?
Access to the school emailing
Records.
list and the school educational
No,
records.
what is happening about the developments of the children in the
Yes.
school? The father can have the access, but ultimately, as the children are in the custody of the mother, she will be the one who will be coordinating with the school.
And it be defined first half vacation, second half vacation, because. it
What
will be
what
clear.
about that?
I will,
Vacation?
whichever they take.
Yes, vacation.
I will say first half.
Then
then.
that first or second, whatever it is, we'll keep it after lunch. Only to that you tell the court will. When is the MC?
MC is in 30th of September.
Huh?
30th September is the next date.
No. Which year is that?
2022 is the
They are not appearing in the MC case themselves. They don't want it. I'm saying take
Unfortunately-
divorce.
No,
I'm
no,
to saying
no.
take divorce.
Unfortunately, no. Unfortunately, this court is not passing any orders, sir, of any of the MCs
Yes, ma'am.
which are later than 2020, because now the season is 2019.
And Rishi, I may be permitted to take my child outside for vacations, outside Bangalore. With permit, I'll give the itinerary.
Only Bangalore. It's, like one,
I know,
You should not be
I'm taking
slow.
baby steps
Yes.
with my babies. That's what I'm doing.
no mentions, I think at 1:30. Please look at the cost list.
What
Yeah.
to do?
Madam, password.
Yes. Passovers.
Yeah, for respond number 1 to 10.
It's the only short question here is maintainability. Why maintainability
Yes.
of the petition? Why we have approached, invoked constitutional remedy? The point here is there is a clear alternative efficacious remedy in appeal. We have not gone in appeal because we are not aggrieved. The order passed by the trial judge applying the law on that, at that time, Supreme Court decision in so therefore, immediately thereafter, what has happened is there were two conflicting judgments. Those conflicting judgments were, I have quickly rushed to the court because my brother passed away. So my colleague called me that I have to come. So I just rushed so that I can just brief the court. What has happened is one matter is Prakash and other Supreme Court, Phulavati, that is the decision 2016, Supreme Court. Then another decision is Dhanamma, 2018. And both the decisions were conflicting because there was some condition was attached. The condition was on the date of amendment, that is 2005, both daughter and father should be alive. It is not retrospective, it is prospective. Then to put an end to that controversy, Supreme Court has taken over and said the provisions contained in substituted section 6 of the Hindu Succession Act confers status of co-partner on the daughter born before or after amendment in the same manner as son with same right and liabilities. That particular principle enunciated by the Supreme Court is the law of the land. So that has to be done. And the Honorable Trial Court has applied the principle which has overtaken by the Supreme Court. So therefore, I am not agreed. I have approached, invoked constitutional remedy, seeking appropriate amendment in conformity with the full bench decision in 2018. So therefore, on the point of maintainability as well as on merits, I will argue before this honorable bench on coming Monday 3:30 because I'll have to rush for the funeral. Next.
But the fact remains is.
I will do it. I will do it.
No, we'll give an opportunity. Constitutional remedy under 226, alternative remedy. Having an, no. 227, question of alternative efficacious remedy coming to the constitutional, we are exercising supervisory jurisdiction, not the inherent or the extraordinary
I will
jurisdiction.
convince this honorable.
But this is, unfortunately,
Monday I
the
will
court
convince.
cannot reject your request, but keeping this matter pending till now of a 2021 without a substance
Yes,
is something.
Just kindly because.
Have it on Monday and
Monday.
I am also expressing that Monday I am going to discuss it.
May I kindly submit?
Monday
One-
30 list may kindly be because morning.
Yes.
session-
May I kindly submit?
Yes.
The suit
Monday,
schedule
3:30
property
kindly.
is a,
No, Mr. Counsel, I am telling you, there is writ petition, whatever or the
is
circumstances.
not maintainable.
Is not maintainable. It has to be dismissed. And your counsel has expressed some the personal inconvenience.
Great.
That's why you're posting it on Monday at 2:30. It will be dismissed.
Highly-
Yes.
Hello.
highly.
Land counsel for the petitioner has has argued on the maintainability and said that he'll come up with further submissions on Monday as he has some personal inconvenience.
Great.
Yes.
My lord, I
Post
appear,
at 2:30.
my lord, I appear for the petitioner,
Which matter?
serial number 4. There is some urgency, but senior counsel is held up in a part-heard matter before Court Hall 8. May I request for tomorrow, my lord? Because the trial court matter is listed day after tomorrow. And this is a writ petition against a 711 rejection application. So there is some urgency because
No, if you have the urgency, morning passed over.
I wanted to.
Again, another,
I understand, my lord. May I only make one request for
tomorrow, no more passovers.
obliged?
Either you're there,
Yes,
Yes.
yes.
morning, the counselor asked for a passover and again in the afternoon, seeking time till tomorrow. post finally tomorrow. No further adjournments will be granted and no accommodation for a Passover also can be entertained. Yes.
Obliged.
Petition.
Yes.
It's the petition filed with husband
Hmm.
against the interim order passed under section 125(1), my lord.
How much is granted?
20,000 is granted, my lord.
When is the order? Date of order?
Date of the order is 11th August 2022.
11th August?
2022. Now they have filed execution, my lord. The thing,
So till he files the execution, it will not see the light of the day.
my lord, the thing is, she has taken divorce by mutual consent. They have compromised the MC petition. She has taken divorce and along with the kid also. There is a visiting rights for the husband that has not been complied.
I'm not on the merits of it.
Yes, my lord.
When an order is passed in 2022, why till 2024? No, no notice is ordered to them.
No order. Now only it is filed. The petition is filed this year only. The writ petition is filed now only, ma'am. Because they have filed execution now after.
No, I think you say it's 5. 5 is 2023 writ petition.
Oh, sorry, 23.
We'll see, take out notice.
Yes.
Petition is permitted to take out notice on the council appearing before the court below and shall file a memo to that effect. Post this matter on 29th. Memo shall be filed by 26th, 25th. Yes. What happened to the password matter?
Lord, serial number 14, my lords, I appear for respondent counsel in this matter. Morning I had moved for an
No
adjournment.
representation for the petitioner. Post this matter for dismissal on 15th.
That's all.
My lords, I appear for the petitioner in serial number 15, please, my lords.
My lordship, for the respondent, sorry. Lordship, my senior isn't well today. He couldn't make it. Please give us a week's time, my lordship.
At the request of learned counsel for the respondent, post this matter on 8/7. How many times?
I'm really sorry. This is the give us a last opportunity, my lordship,
My
please.
lords, I have one submission, my lords, in furtherance of this. My lords, the interim amount is 50,000, please, my lords. Each passing day, I am paying 1,500, and they have completely refused to address
We'll have it
arguments at
tomorrow,
all
no further
instances.
adjournment.
Much obliged.
Post this matter
Grateful, my lord.
tomorrow. At the request of learned counsel for the respondent, no further adjournments will be granted.
Much obliged, Mr.
Grateful, my lord.
No,
petition.
what happened to that Passover matter?
Item 13 it was.
Then it's not called, no, that instructions to be obtained with regard to that order, which first quarter or second quarter?
First half, second half vacation. We'll take the first half.
In that order, the father can exercise the first half of the vacation.
A study of is the on major festivals. Major festival, this honorable court said that
5 to 7.
5 to 7. Let it be in the morning, morning.
In the morning.
He has to come from Bombay, Ladyship.
Not this matter.
He'll come one day before
So I'm just,
matter.
no, Ladyship, it's 5 to 7 in the evening. I'm just saying he has to come from early morning, at 3 o'clock he'll come.
No problem.
Then
10 to
Morning?
12. Morning 10 to 12.
10 to 12.
they,
For the festivals, I've already
Yes.
dictated
Ladyship,
the
one
order.
thing I'd like to say one thing, Ladyship, here.
10 to 12.
Yes.
I'll just say something. Diwali, there's a puja, which is the auspicious moment is in the evening, always.
What
It's-
about her?
Ladyship,
For her, it is not a precious moment.
Ladyship, I'm saying that for 2.5 years, I've not celebrated Diwali with my children.
Doesn't matter, doesn't matter. It is not, it shouldn't be structured too
And
much.
Ladyship, there's one
Yeah.
more thing I like to add.
Yes,
Like, my mother has not seen the child. For vacations, can she come?
he can.
I'm so grateful. Can it be recorded in the order, Ladyship?
Yes. His mother can see the child.
Yes.
When he was having.
Yes.
It's all the more good.
If she comes down, yes. why
Whenever,
not?
during the, while exercising the custody of the
Custody.
children, mother can also.
I'm so grateful.
accompany
I'm
the-
so grateful.
Grandmother can accompany the father.
I'm so grateful. I'm so.
My lord,
Thank you.
in a transfer petition, my lord, between the parties, there is a reference for early decision in the matter without unnecessary adjournments. That is the
Leadership for that.
Honorable Apex Court,
his petition.
Yes, yes.
Yes.
It is for both my GWC.
the Honorable Apex Court has directed, maybe the Supreme Court was referring to the IS,
Yes, no,
not
Supreme
the
Court.
final hearing.
No. It was only on the point that,
Petition.
Main
no,
petition.
only on the IA.
It is not.
I'll show the order. It's only the IA because we asked for visitation rights.
Because Honorable Apex.
We only
Court,
want my visitation rights.
why should,
Yes.
when they themselves are saying that the Constitutional Court shouldn't pass any orders, that too in a 2022 writ petition, why would they say that?
It's for
it should be
visitation.
done It is, the Honorable Apex Court might be referring to only the IS.
Yes. And here, and Apex had also said, settle the matter. They don't want to
I
do.
don't want to.
Let's
enter
read that
into-
line also that you should settle. the
One
matter.
more thing is,
Any
the court below shall not grant unnecessary adjournments to either of the parties.
In
And
both
shall
them.
proceed with them in GNWC as well as
As well as the MC petition.
MC and proceed with the matter as expeditiously as
Please,
possible.
I'm obliged to this.
Yes.
Paper petitioner,
Yes.
the petition, sorry, the petition. Same is number 760, number 18, before it tried to put under section 125 of the,
How much is the maintenance granted?
no, not at all granted. Dismiss by
Dismissed.
default,
Dismissed.
dismiss by default.
Dismissal. Then you filed a restoration petition?
No, madam.
It's 125 CRPC. Where is that order?
Page number 20, madam,
Page number?
20.
Petitioner called absent, kept by for evidence. Petitioner and counsel called absent in spite of respondent having filed objections. Address arguments on IA number 2. So for this reason, from 23/12/2022, this is here.
Yes, madam. My lord, what happened? During the pendency of the pandemic, she was unable to meet his counsel.
My lord,
And his counsel also expired.
my lord, I have one submission to make. The ground urged by the petitioner is that the council passed away. May I read, my lord? It is-
No.
It is very
First of
relevant
all,
because they are
no.
misleading the court.
First of all, no, not about that. First of all, why is this when the court itself is dismissing the application for default?
Certainly, my lord.
Court should record the reasons.
Certainly, my lord.
Let's forget about his reasons.
Certainly, my lord. My lord, but the ground urged before this court, the petitioner is misleading. They have urged the ground that the council passed away during the pendency. My lord, may I draw your lordship's attention? Page number 12. I'll just apprise that.
Why the
your
court
lordship.
is not looking at it is, even if you show,
Certainly,
it's
my lord,
not going
certainly.
to make any
But-
difference.
But my lord, the petitioner ought to have come to the court with clean hands. At page number 12, my lord, of the annexure A.
Yes.
Lord, it is at the bottom, the date is 28/1/2019, my lord. At the following page, my lord, page number 13, if I may read, my lord. First petitioner and respondent present, Shri PAR and Shri MAH advocates files wakalat for petitioners and respondent respectively with IAs under section 13 of Family Court Act. Now, my lord, erred on IAs and they are allowed petitioners and respondent are permitted to engage the service of counsel. Both parties are directed to appear before the Bangalore Mediation Center on 28/2/2019. Lord, the only ground urged here is that the counsel on record, Shri Seturaman Sabapati passed away, but my lord, he passed away on 18/1/2019. 28/1/2019, another advocate comes on record, my lord. Now that they have suppressed it before this court. That is all is my submission, my lord. I leave it to your discretion. I bow down.
Please come. No, when the court is dismissing, at least court should record. This is how it has happened. So many times he was not present or she's not prosecuting the matter properly. Nothing. Morning call, evening
My
call,
lord,
absent.
In the order sheet, she has remained absent for 10 dates, my lord. It is in the very order sheet it is mentioned. The annexure A submitted by the petition.
Which cause will allow this?
I bow down to your lordship.
Agreed with the order passed with the court below, dated 23/12/2022, whereby the court had dismissed the petition filed by the wife seeking maintenance under section 125 of the CRPC the petitioner wife is before this court. It is stated that the court, the dismissal matter on 23/12/2022, observing that the respondent is present, petitioner called absent, kept by for evidence, case again called at 5 p.m. Petitioner and a counsel called absent. In spite of respondent having filed objections to IA number 2, petitioner had not opted to address arguments on IA number 2, and thereafter, in spite of scheduling the matter for evidence on 24/6/2022, not opted to lead evidence. Hence, petition is dismissed for default. Now, the present writ petition came to be filed stating that the advocate who was representing was no more. As such, the matter could not be represented, and hence the order may be set aside. Next para. Learned counsel appearing for the respondent husband submits that the petitioner has not come to this court with clean hands. In fact, the advocate who was pursuing the advocate died on 28/1/2019. Thereafter, they have engaged another advocate.
On
28/1/2019, and such a fact, and they have come before this court with all misrepresentation of facts, and on that ground, this writ petition is also, as a writ petition also has to be dismissed. Next one. Having heard the learned counsels on either side, peruse the material on record. This court has perused the order passed by the court. The court, except stating that on a particular day, there was no representation. No, I'm looking at the order.
Yes, my lord.
Except stating that on a particular day, there was no representation, has not stated any valid reasons for dismissing the same. Learned counsel for the respondent submits that on 10 occasions earlier, the wife has not represented the matter.
Lord, as per Apex Court's order, Rajesh versus Neha, both the parties were directed to file assets and liabilities declaration. And for that, from 30/1/2021 to 23/12/22, they have not filed the assets and liabilities. That is also another reason why it was
It is
recorded in the
stated that
entire
as per
order.
the law laid down by the learned counsel further, it is stated that as per the law laid down by the Honorable Apex Court and Rajesh versus Neha, the wife had not filed her statement of assets and liabilities. That's how the court below had dismissed rightly dismissed the petition. It's an application filed under 125 CRPC seeking maintenance. This court has also recorded the contention of the learned counsel for the respondent and also perused the material on record. No doubt, there are lapses on the part of the on the part of the wife in pursuing the matter and pursuing a matter in the in doing substantial justice and in the interest of the parties. This court deems it appropriate to set aside the order dated 23/12/2022 on the condition that she shall pay an amount of ₹1,000 towards cost to the respondent. Accordingly disposed of. And the court, without granting any further adjournments, shall proceed with the matter. Yes.
For petitioner, my lords, kindly pass over the matter, my lords. My senior is stuck in another proceeding, my lords.
Give the.
Submission, I'm referring R1. Even though we are also agreed by that impugned order, we have not filed the separate writ petition challenging the impugned order.
At request of learned counsel for the petition, list this matter next week for orders. Interim order earlier granted is extended till then.
In both serial numbers.
Huh?
Both the serial numbers, my lord.
That's what.
Please.
Much more.
My lord, one submission.
It's a 2019 CPC matter.
My lord, one submission in both the matters, my lord, the impugned order is the same and we are seeking for the same prayer. My lord, so.
Both the parties
maybe
agreed by the order,
dispose
but
of.
first defendant has not.
So
filed the-
that's how the order is.
No, we have filed objections regarding commission report.
Let's see what is the order. Let us see. Page number?
My lord, page number 41 in WP number 22181.
30?
34 is it?
34 ಯಾವ್ದ್ರಲ್ಲಿ?
Writ petition.
I am looking at
22-181.
WP 22181.
Yes,
Please, my lord.
That is 34, madam.
34. These are your objections.
Page number
I'm asking
14.
to the
44 maybe because there are two numbers, madam. 44 and 34.
Let's read the order at 44. What is the suit?
Suit is
Suit is
for
for declaration.
declaration and possession, my lord.
Who are you?
I am defendant number 2.
And the first defendant.
Is the
He's the
plaintiff.
plaintiff, my
Is
lord.
the plaintiff.
Plaintiff in a suit for declaration.
Declaration and possession.
Ah.
And the court commissioner is appointed, my lord.
Hmm.
And the plaintiff as well as defendant number 1 and 2 are
Court
agreed
commissioner appointed for what?
for measure
Here, the
the
encroached portion. It is his allegation that we have encroached certain portion of his property. For that purpose, commission was appointed. And memo of instructions was also given by both the parties. The grievance is that the commissioner has not followed the memo of instructions given by the parties.
Let's read this. Please read.
Into order, madam. The plaintiff has filed a suit against the defendants to declare that he is the owner of a scheduled property bearing site number 215, measuring 60 into 40 feet in survey number 505/P2 situated at Hiramangur village, and sought for possession of B scheduled property bearing site number 215, measuring 60 into 35 feet in survey number 505/P2, and C scheduled property bearing site number 215, measuring 60 into 5 feet in survey number 505/P2 situated in Hiramangur village of Chikkanur Taluk on the ground that he is the owner of plain scheduled properties, and the defendants have encroached B and C scheduled properties. The defendants have registered the suit by filing the return statement denying the material averments made in the plaint and alleged measurement of B and C scheduled properties. This court has framed the issues on 23/3/2015. The plaintiff got examined himself as PW1 and got documents marked as exhibit P1 to P14. On behalf of the defendants, two witnesses have been examined as DW1 and 2 and got documents marked as exhibit D1 to D5. It is after closure of the evidence of both the side, the court commission has been appointed to ascertain the measurement of site properties bearing site number 215, 214, 215 and 216 and to submit the report along with the sketch, and accordingly he has submitted the report along with the sketch. CW1 has stated in his evidence that he has received the commission warrant by exhibit P1 while dated 22/7/2017 and accordingly has issued notice to both the plaintiff and defendants while dated 11/9/2017 and fixing the date of measurement of property on 27/9/2017. It is the further evidence of CW1 that on 27/9/2017, he has visited the plain scheduled properties, measured and demarcated the plain scheduled property in the presence of plaintiff and defendants and also the witnesses. He has prepared the Mahazar wide exhibit C3, prepared the rough sketch wide C exhibit C4 and compared the memo of instructions wide the exhibit C5 and to C7 and submitted his report along with the sketch and Mahazar. The plaintiff has contended that court commissioner has not mentioned exactly as to how many feet the defendants have encroached the property belongs to the plaintiff as per the memo of instruction filed by the plaintiff. Further, the defendants have contended that the court commissioner has not compared the memo of instruction and also not measured site number 194 to 220 and also not measured the road. The defendants have not encroached any property and the court commission has not properly measured and the court commission has not taken into consideration of correct measurement and also not obtained any layout plan. But though the plaintiff and defendants have taken this part contention, same has not been amplified before the court in any manner. Nothing is elicited in the evidence of CW1 to discredit his evidence or to reject the commission report. Of course, it is suggested to PW1 on behalf of the plaintiff, it has to be CW1. Of course, it is suggested to CW1 on behalf of the plaintiff that he has not mentioned the encroachment of site number 215 by the owners of site number 214 and 216. It is further suggested on behalf of the defendants that he has not complied the memo of instructions properly and given wrong answers to the memo of instructions.
Please come to your memo.
My lords, I have another matter in 12, my lords, I have. to
Mine
rush.
is at 27, madam.
I have another matter at serial number 99 at 12, my lords, 98 is gone, I have to leave.
Leave. The case will go on. You leave, yes. You can go.
Yes.
Yes.
Mine is at 27, madam. 26 is by the plaintiff.
Please read what was not complied with.
My memo. Memo of instructions filed by the first defendant to the court commissioner. Court commission.
Read
Court
that.
commissioner to give at least 7 days prior notice to his visit to the spot to all the parties to the suit with proper acknowledgement. Court commissioner to say, is it possible to locate and identify the site as per layout plan approved by SUDA of the municipality? Number 3, court commissioner to take with him the approved layout plan, if any, from CMC or SUDA, and also that marked as Exhibit P8 in the suit, and to say whether the layout plan maintained by the CMC or SUDA and Exhibit P8 are one and the same or not. Number 4, court commissioner to locate the 30-feet road situated on the southern side of the sites 218, 219, and 220 first, and then proceed to locate the sites as 218, 219, 220, and then to measure all the sites bearing numbers 194 to 220 as per the respective measurements or dimensions of sites as mentioned in the rectangle space in between sites number 200 and 211, and also taking into consideration the measurements that
Please tell the court which of these are not followed.
have to look into paper melon, because even though I have agreed by the order, I'm representing the first defendant, but we have not filed any separate writ petition. So these are the contesting.
He has to, yes. Which are that? Which are not complied with?
My lord, their contention is that the
Their
court
contention,
commission.
plaintiff's case is different.
Please, my lord.
Plaintiff's cases, which is the encroached portion, is not stated by the court commissioner,
Please,
that
my
he
lord.
has stated.
Please, my lord.
Now, your case is that that map is not taken, your instructions have not been followed. Which instructions?
Please, my lord.
At page number 27.
29.
This is by whom? This is by you.
27 is by me.
So anyway, you have not filed your writ petition.
Yes.
So that need not be. Now let's come to your.
Please, my lord, in writ petition number
I
52439.
think like what you have said, you also said the same. Running into 10 objections. Same.
Most
Your-
similar contentions were
No,
taken by the
yours
defendant.
is in big font, yeah, his is in small font. That's the only difference. What he has not complied with?
Please, my lord. My lord, the court commissioner has not obtained the necessary layout plan and he has not given the basis for which he has taken the measurements, my lord. It's not been produced with the commissioner's
That's
report.
one.
That's one. And
Then basing on what he has measured the land?
he in his cross examination he says that he alleges that he has used the layout plan produced by the plaintiffs and the defendants, my lord, but he hasn't produced any necessary documents, and also
That's what
in
the
the
court-
sketch.
That's what the court says in the cross examination. Nothing could be elicited by you, saying that he has not followed the instructions.
Please, my lord. And my lord, even in the sketch, the measurements have been shown, wrong measurements have been shown, and even the dimensions and the like some sites are rectangular in shape, some sites are trapezoid.
Where is the cross examination of that court commissioner?
Page number 38 in WP number 52439.
30.
Give the next
Five.
petition. Next petition.
It is in Kannada.
It's in Kannada. File a translated copy of 35.
35 minutes.
The examination of the court commissioner,
35 to 40 minutes.
30, placed at 35 to 40, which are in Kannada. A translated copy shall be filed by post on 22nd.
Much only.
Please, my
Interim order is
22nd.
lord, interim
Not
order may
22nd,
kindly be
23rd.
extended.
no, it's interim.
Interim order may kindly be
Interim order earlier granted is extended to the next date of hearing. Next,
in both the serial numbers.
Huh?
In both the serial numbers.
in both the
Yes,
serial numbers
please.
15 and 16, yes.
In this case, I am
Please, my
appealing for the petitioner's counsel. Item number 18.
Yes,
I am for the petitioner's counsel. This is the petitioner is the wife and the respondent is the husband, arising out of the proceedings from a family court. Today, my request is that my Lord learned counsel on record is unable to come on account of ceremony of the father in the house. So, he could not inform on the previous day. Any other date, I am instructed to request for a date. Any other date, my Lord. There are certain directions of this honorable court with regard to the custody of the child. Please,
father ceremony today.
father ceremony.
I understand that, my lords. My lords, anytime in this week, my lords, because there are,
Matter on 10th,
Please,
at the request of learned counsel for the petitioner, no further adjournment. Yes, next.
please.
Give the docket. On 11/6/2024, 12/6/2024, there is no representation on behalf of the petition, on behalf of the parties. Again, on 4/7/2024 also, as there was no representation, this court directed the matter to be posted under the caption for dismissal. Today also, there is no representation. It appears that the petition is not interested to pursue the matter, dismissed for non-prosecution. One more line to add. This is a writ petition of 2017. So far, the steps are not taken by the petitioner.
Till number 20.
Is it displayed in the notice? This is a writ petition of 2018. And notices are not served till now, as no steps were taken by the petitioner. When this matter came up on 4/7/2024, as there was no representation, this matter was directed to be listed for dismissal today, same order. Dismissed for non-prosecution.
Trial court has passed a 25,000 order.
Hmm?
Trial court has passed the, again, 25,000 order has been passed, your lord. This honorable court has modified as a 15,000, your lord, at the time of admission, your lord.
I think this came up on the last occasion. Why is it adjourned?
Last,
But this affidavit was not filed, but since assets and liabilities, it was not filed. Lordships directed both of us to file, it's filed.
No, I think after that.
Thursday,
also it was,
Thursday it's a file. Your
Why it was adjourned?
Not,
is not-
I was not sat.
You were not there. Hmm.
I ನಿಮ್ದು arguments ಆಗಿದೆ.
It started. You.
Huh?
Both are doctors, your lord.
Hmm.
She is the dentist.
You said that she's working. And that fact was not stated before the court.
On the paragraph 10 years, no, your lord. The paragraph 10 years says that she was at the time of marriage, even after the marriage also, she was working, your lord.
Hmm.
After that, she pursued the 3 degree, your lord. Kindly see the assets and liability she has filed, your lord. Two of the assets and liability of the respondent, your lord. Page number 2 of the assets and liability. Of respondent. Page number 2, your lord. Qualification of the
Hmm.
BDS, dentist, your lord. And PG CCIO, it means postgraduate certificate in oral
Where are you
implication.
reading?
But sir, my
Respondent
documents are
mail.
produced on 23/6.
No, I have seen it, para two,
Yes,
that is Dr. Preetu.
yes.
Please, your lordship.
Uh,
Page number 2, your lordship.
Qualification, BDS, FMC.
Postgraduate, the postgraduate certificate in oral impetology
Hmm.
and FMC,
Hmm.
fellowship in medical cosmetology.
Hmm.
She is dentist, your lordship. She is the postgraduate, your lordship. She says that she is not working. She is a medical course, it's a professional course, your lordship. At the time of marriage, in the para 10, in the petition itself, they admitted that she was working. Even after marriage also, she was working, your lordship. After filing of the,
That she's not working, the court has granted this.
your lordship, it's a professional.
No, on the ground that she's not working, court has granted maintenance.
Yes.
Court below.
Yes.
Now, let us see according to her, what are where are her bank statements? Where did she file? Without filing the bank statement, just like that filing this, what is the purpose of it? This is to counsel.
Yes, Minister.
Where are the bank statements? What is the balance? Please file that. The counsel appearing for the respondent shall file before this correspondent by, shall place before this court the bank statements of the respondent from the when was the maintenance granted?
From 2017.
17.
17, from 2018, 17 till now. Pose this matter on 22nd.
Please.
Case in this case appear for petitioner. Petitioner counsel is gone out of station for attending his brother ceremony. Tomorrow I have it, tomorrow I will argue the matter.
You have no advocate?
I appear for
Tomorrow I have it, tomorrow I will.
appear for respondent wife, my lord. My lord, kindly see the case, my lord. 2017, he has not paid a single pay.
Tomorrow we will take.
Yes,
She's telling some person inconvenience.
Tomorrow.
Pose this matter tomorrow
Much obliged.
at the request of learned counsel for the petitioner. Yes. You the rocket. As there is no representation on 21/6/2024, and the steps are not taken by the petitioner. This matter was directed to be listed for dismissal today. Today also there is no representation. It appears that the petition is not interested, accordingly dismissed for non-prosecution. This matter came upon 21/6/2024. There is no representation, since steps are not taken, same grounds, dismissed for non-prosecution.
Appearing for petitioners, my lord. My lord, the order passed.
Non-compliance of office objections raised on at scrutiny stage.
Scrutiny stage, IA is supposed to be filed, my lord, it seems, my lord. Interim order is already.
Following objections had to be completed, IA to be filed as per order. Objections to IA, if any, to be filed. Neat index and
My lord,
memorandums in
I have
office.
complained, my lord. Last occasion I have complained. IA should be filed, my lord. I may file it. Apart from that, all office objections I have complained, my lord.
Non-compliance of office objections raised at scrutiny stage, same thing.
Same thing they have mentioned it, my lord. IA is supposed to be filed, my lord. I made a mention that interim order is already passed. Since interim order is already passed, IA is not necessary. If at all they require, my lord, I will file it, my lord.
what they require.
No,
They
my
have
lord,
to
if they
file.
want, my lord, if
The petitioner shall comply with the office objections by 11th of July, or else the petition shall stand dismissed.
my lord, the
That's
interim
the
order
law.
maybe,
Huh?
interim order,
But it was not extended on the last
not
occasion.
because of, my lord, it was posted for dismissal, my lord, I was there, my lord. By the time I reached, my lord, matter was over, my lord. I met the lady also. I requested,
That's what will happen if you don't represent.
yes, sorry, my lord, but interim order 4/8, my lord,
For that, when was the interim order?
4/8. Last occasion also I mentioned, my lord.
Since that? After that, how many times it has come up?
Just
No,
2 times,
no,
last
how
time
many?
didn't reach, my lord.
No. 4/8 is the interim order.
Yes, my lord.
21/6, it is not adjourned.
The last occasion,
1 minute, 20.
I have made a mention also, my lord.
Interim order earlier granted is extended. till
Much
then.
obliged.
Yes.
Here for the respondent in this case, we.
Because it is vacant stay.
Yes, ma'am.
No representation for the petitioner, none counsel for the respondent is present. Poses matter for dismissal tomorrow. Yes.
Petitioner,
Huh?
kindly
That is
pass our
posted.
lordship. India is held up in other court. Kindly pass
Okay.
our lordship.
Tomorrow,
It'll come.
tomorrow.
Yes, lordship.
Today it is posted for payment of arrears. If not, not dismissal. Last occasion is.
If you can wait, we will pass.
Please, please.
Pass our lordship.
Tell the court officer,
Yes.
once your senior comes.
Yes, lordship.
Yes.
My lords, I appear for the respondent in serial number 28. I was not informed about the adjournment
Something was said, they said somebody not well or something.
because it was for the final hearing regarding child's custody. The stay has been granted. There was a stay in the child custody, child visitation matter, my lords.
When is it adjourned to? You filed vacate stay.
Yes, I have filed a vacating stay application.
It is posted to 22. Learn counsel when the matter, when the matter is called, learn counsel for the respondent submits it without informing the respondent, the time is sought, and they have urgency in the matter, as there is a stay. Post this matter on 15th.
Much obliged.
Yes. Yes.
This matter, I'm for the petitioner. But it is,
This is the respondent.
the last occasion also he was absent, my lord.
They were absent.
Mediation failed, my lord. The petitioner is the wife, my lord. She has filed the petition.
So we'll post it tomorrow as part her.
Please, my lord.
Part her.
Please, my lord.
Give it.
For enhancement of the.
Heard the land counsel for the petition in part. On the last occasion also, there is no representation on behalf of the respondent. For giving an opportunity to the respondent, the matter is adjourned to today. Today also, the respondent is not present. Post this matter tomorrow as part heard.
Please, grateful.
Yes. Same. For dismissal day after. No representation for either of the parties. Same order, day after tomorrow. The respondent. Yes. The move for retirement filed by advocate for the, that is your entered appearance.
I entered.
Why is it coming up for instructions?
Your Honor, the
Yes,
matter
It came
was,
up on Friday.
yes, ma'am, can be, it was.
No
listed-
representation for the petitioner. Post for dismissal day after tomorrow.
My lords, obliged.
Yes. Counsel for the respondent is present. Yes.
For the respondent, my lord. Respondent.
Furnishing of so and so to issue.
So
third
that
type
I will
says-
take steps for the others, but in the
Copy is not
meantime, I have
resumed.
filed one application. The court, after issuing notice in the writ petition, stayed further proceedings. Then defendant 6 to 12, started, entrusted the property to a joint developer. He started the construction there. Then I filed an application to impede him and as well as an injunction order against him not to put up any construction. The trial court said, since there is a order staying further proceedings, I cannot do anything. Then I filed an application before this court, and this court relaxed the stay order and directed the trial court, I mean, the court may look into that order which is dated 23/2/2020.
To be done now.
Now, now, as far as 6 to 12 is concerned, my applications are concerned. I have been able to obtain an order of temporary injunction against them. Now, the other defendants that are entrusting other property for joint development agreement, this stay order was relaxed only to consider my case against defendant 6 to 12. Now, the other defendants are indulging in same this thing entrusting. Therefore, I have filed the present application. Stay order may be modified so that the trial court can consider.
Then
Huh?
what will remain then?
No.
The stay is granted.
Stay
No.
of the further proceedings is granted. That should not come in the way of the trial court considering the interim applications filed by me. That is my prayer. Now defendant.
Why notice is not served on this?
Let's, I have paid the process the day the matter is admitted.
When was it paid?
Here, I have taken steps twice. I will take.
It's coming up for.
Some of them are.
Why is it not served on them?
It's that bit difficult unless I look into the postal industry.
Look at it.
Say that. But in the meantime, and all that I am asking is.
No, if it is no such addressee, what is the purpose of taking the notices again and again? What is the postal shara? Respondents 12 to 12, 13, 17, 18, 20, 21, 20, 27.
Meantime, the court may come to the order passed on 23/2/2023.
That's not connecting to this. Look at the postal shara. What is the postal shara? Then there is their duty to inform the address before leaving. That is first time. Second time what happened? No, it is third time it is coming.
The second time.
Second time when it was listed, the court permitted me to pay fresh process. I have paid that.
When was it paid?
16th March 2023.
It is posted for in the month of July for taking steps. Take out step, please.
I will take that, but please understand my problem. That's the defendant 6 to 12 were starting putting up construction.
You appear for which defendant?
And for the
He is not a defendant. He was sought to be impleaded. My impleading application is dismissed. That is what I have challenged here. He appears to be one of the proposed defendants.
It is submitted with the learned counsel for the petitioner that this court had initially granted stay of all further proceedings.
Then on 23/3,
It
it
is
relaxed
stated
the
that
stay.
during the subsistence of the said order, defendant number 6 to 12 entered into joint development agreement with the developer. When he filed an application under the Order 39 Rule 1 and 2 of CPC, as there is a stay by this court, the same was not considered. Then this court had clarified that the stay would not come in the way of deciding the application filed regarding defendant number 6 to 12 and also the application to implead the developer. After such orders are passed, the proceedings would again subject to the interim orders passed herein. Next one, Land Council appearing for the petitioner. Where is that IA?
This IA is filed on IA 1 of 24.
It is submitted that again
Defendants
now, defendant number
1, 3 and 1, 3 to 5. Mention that in my application. A schedule items.
now, now the defendant numbers 1, 3 and 5 are again trying to create third party rights by way of joint development agreements. Hence, he wants to file an application restraining them from indulging in such acts in view of the stay order granted by the court. The trial court is not entertaining the same. Considering the earlier orders passed, this court is inclined to, this court is passing the order directing the court to entertain the application filed by the petitioner. And once the said orders are passed, again the order impugned, the interim order granted by this court would again come into force. The petitioner shall take steps for service of notice on respondents by 18th, or
Right.
else the appeal stands dismissed. The petition stands dismissed without further reference to the court.
Slight factual mistake. No, it's not defendants 1, 3 and 5. It is against defendants with respect to items 1, 3 and 5.
Defendant one,
All the defendants
give you correct to correct that.
with respect to items 1, 3 and 5.
Defendant number one, in respect of item number 1, 3 and 5.
No, all the defendants with
The
respect to
defendants,
items 1, 3 and 5.
the remaining defendants, all the defendants in respect of item 1, 3 and 5 of the suit scheduled property.
Great.
Yes. Disposed of. Yes. You that. Steps not taken for service of notice. This court on this court on this court on 5/6/2024 granted 2 weeks' time for taking steps. If the steps are not taken, the petition shall stand dismissed without further reference to the court. As per the office note, it appears that the petitioner has not taken the steps as per the order passed for this court. Hence, the petition is dismissed. For not taking steps.
Lord, the petition is before this honorable court, being agreed by the,
No, furnishing of so and so
My
to
lord-
issue second time notice.
my lord, I have taken steps.
I gave for bringing LRs of deceased petition number 1.
No, I have taken steps in 21 itself, my lord.
Not 21, this is the latest version now.
I have given the process twice,
When is it the latest endorsement?
and he is deliberately avoiding the service of notice, my lord.
Services away.
Mm.
So far the technology is not yet from the postal department, still it is in away. Permission.
Unsert cover returned.
Get an
Ah. With insufficient address.
He's avoiding the notices of this honorable court.
No, insufficient address, that's what it is
No,
saying.
we are going to, 2 addresses I've sent two addresses, my.
Then why don't you take a substitute service application?
My lord, he is coming to the trial court. He has got a interim order till the disposal of the suit. And deliberately he is
No interim
dodging,
order in this?
my lord,
There is no interim order in this?
no, not in this, my lord. There is no interim order in this. May I
Yes.
make one prayer, my lord?
Submitted that,
My lord,
the-
my lord, may, this petition may be disposed, directing the trial court to dispose the suit
Pending suit.
within 3 months.
What is,
First-
suit is which year?
So of 2020, my lord.
28.
Sorry, 2018.
We'll say expeditious.
Time limit maybe. Please, my lord.
We don't
It's
know
a-
what is the pendency in that court, and it is
My lord,
difficult for them to even to adhere to the timeline.
my lord, every time he is seeking adjournment
That will say that not to grant any further adjournments unnecessarily.
and
to
the
dispose of.
timeline, my lord.
It's not possible.
Maybe 4 to 6 months.
Agreed with the order. Passed in. Where is IA?
I is at page 67, man. Order is at page 87.
Agreed with the order, passed in. Not 27. Agreed with the orders, passed in. Which IA? IA number 2, 3 and 4.
I number 3.
Agreed with the orders, passed in.
I number
I
3.
number 3. Dated
3 and 4, my lord.
35. 3 and 4, that's what 2 IAs are there.
Please.
Agreed with the order, passed in I number 3 and 4, dated 35/2020.
Please.
You are the plaintiff or the defendant in the suit?
There, I'm the defendant.
The defendant is before this court. When the matter came up for admission, then counsel for the petitioner submits that as this is a petition of 2021 and the suit is of the year 2018, the trial court may be directed to dispose of the writ petition as expeditious in a time bound manner. Next para. Then counsel the petitioner has requested for a disposal of the MC. This court is not going into the merits of the matter. Accordingly, the writ petition is disposed of, directing the court below to dispose of the pending suit as expeditiously as possible. And the court shall not grant unnecessary adjournments. Next para.
Ma'am.
Disposal is in the interest of both the parties. This court, as such, though notice is served on some of the respondents, still this court is passing the order without waiting for service of notice on them.
My lord, outer limit of the 6 months.
1 year.
6
As
months,
expe-
6
as
months. my lord.
expeditious- That's why I'm saying, if I don't say, she'll do it judge will do it in a fast way.
Please.
Yes. Yes, next.
Much obliged, man.
Yes.
Served a copy to the trial court of the court. Query for the defendant.
What is the name of the advocate?
Shiv Kumar.
In the name of Mr. V. Shivkumar, learned counsel for the petitioner submits that as per the orders of this court, he had taken out notice on the counsel appearing with the respondent before the court below, and you have filed a memo to that effect. In the name of Mr. T. Shivkumar,
KV Shiv Kumar.
A.V. Shivkumar, advocate for the respondent. Post this matter day after. Yes.
Madam, appearing for a petitioner, my lord.
Week's
But-
time.
1 week time.
Week's time.
1 week time, kindly request 1 week time.
A week's time, default order.
For respondent.
Yeah, for the respondent. Let us see that. There is a memo for. It's an, when this matter came up on 25/6/2024, this matter is adjourned, and this court also found that, except saying that they've written the papers, nothing has been mentioned. As such, this memo of retirement cannot be accepted, and directing the council to furnish the details. Today, there is no representation on behalf of the petitioner.
38, I thought it was 36 minutes.
Huh?
Previous council has given no objection certificate. Subsequently, I filed power for the petitioner. Samson. 38.
You have already filed wakalat
I filed wakalat
for petitioner.
for petition.
Land Council, Mr.
K. Shamsundar.
K. Shamsundar submits that he has filed wakalat for the petitioner, print his name, post this matter on 2022, post this matter on 18th. Yes. Delete the name of Pujappa J. K. Shamsundar also. Yes.
39, 38 and 39.
No, he said Vijay Kumar or something.
Shamsundar.
Shamsundar. Delete the name of Pujappa J.
Same petitioner, same.
Same, in this also, delete the name of Pujappa J and post this matter on so and so. Yes.
What's up?
Yes, for petitioner, they appeared for respondent 7 and 8. R4, R7 and 8 served by
R1, R3, R9 not served.
not served.
Unserved covered road. Shara,
R5, R6 served by.
as far as R5 and R6,
Served.
as per the postal Shara, have refused amounts to deemed service of notice. R10, in respect of R10, returned as unclaimed, that is also deemed service of notice. Then now what about R1, R3 and R9? The petitioner shall take steps in respect of R1, R3, R9 within a period of 1 week, same default order. Yes.
Apply.
Taken steps.
My senior is not very well, he is in
Huh?
hospital. My senior is not very well, he is in hospital. Kindly give for registered ma'am for hearing case.
It is, when was this order passed? 5/6/2024, 2 weeks time is granted for taking steps. It is submitted at the land council, the petition is not well. Finally, a week's time is granted for taking steps, or else the appeal, the writ petition stands dismissed without further reference to the court. Yes. You that? Where is the office note? No office note. How will we know whether post will be to the court? Not complied with the office objections. The why is it this was where is that order? 1 minute. It's only post for dismissal. But it is not posted for dismissal. It shouldn't be like that, no, post under the caption dismissal. The 21/6/2024. As there was no representation on behalf of both the parties, this court has directed the matter to be listed for dismissal on 21/6/2024. But it is not listed under the caption dismissal, and at the same time, there is no representation on behalf of the petitioner. Post this matter under the caption for dismissal day after tomorrow. Yes.
Hearing for the petition, Lordship. We have served the copy, Your Lordship, on
And counsel
27.
for the petitioner submits that They already served the copy on the advocate for respondent.
P. Kumar may be shown in the respondent.
Print the name of Mr. P.
Prasanna Shetty's, your lordship.
Print the name of Mr. Prasanna Shetty. Post this matter on 12th, no, not 12th, 11th.
Your lordship, kindly have it on 15th, 11th and 12th, some inconvenience.
15th.
So obliged.
Copy served to the Learned Council, madam, who is appearing in the trial court, madam.
You have to file a memo, not like that.
Sorry, madam, today I received it. I'll file it in tomorrow, madam.
Post
in
this
the
matter
office.
to, post this matter on Wednesday.
Grateful.
In the meantime, and that counsel seeks, the request that the matter be taken up on Wednesday, so that he'll come up with a memo that he has complied with the order passed with the court. Yes.
Grateful.
For the respondent, madam.
Complaints of office objections raised on joint parenting plan. That is counsel signature not forthcoming.
Yes, ma'am. I have given only I have served a copy on him and I filed it. I asked my colleague to just put a signature on my advocate for a petitioner. I think he has forgotten. The only thing we have served a copy and they also served me a
I
copy.
have also, respondent also served a
Served a
copy.
copy.
to this,
It can be referred for mediation.
It can be referred.
Can be referred, can we work it out?
Both the parties have come up with a joint parenting plan and both the councils submitted, take that also. Both the
Copy
councils
served, my lord, already.
submit that. The matter may be referred to the mediation center. Where do the parties live?
Respondent stays in Mysore, my lord.
She said in
Petitioner
Mysore.
is in Bangalore.
Petitioner stays in Bangalore.
Mysore. The parties are directed to be present.
Here mediation center.
Before the mediation center, Mysore. Anyone is going to see the kid.
No, even I have to go.
If you are going regularly, go there.
No, I am not going there, madam.
No, you means the advocate has to go. But
Here advocate is
both the
present.
parties
Can come, my lord. For us, what happens is suddenly.
both the
High Court
parties are directed to appear before the mediation center when? Bangalore, when?
Any date.
Any date, I will seek the instructions from.
Saturday.
Any Saturday.
Any
No,
Saturday.
Except Saturday, my lord.
Saturday.
Saturday, I go out stations.
How can it be then if you don't there, somebody else will be there? Because she is working now.
No, any date.
Post on 20th.
Much of 20th. 20th.
20th Saturday at 3 p.m. In the Bangalore Mediation Center. The Registrar Judicial is directed to communicate the same.
One humble submission, my lord. The pending maintenance is only 2 lakhs is pending. Let the petitioner be complied with that, my lord. My humble submissions. Why? Because.
Oh, one way.
Okay, after the mediation, yes, ma'am.
Then it will
After-
come, we'll
Yes,
see.
ma'am. Yes,
Yes.
ma'am. Much of.
One submission, my lord. I may be permitted to sign that.
Petition council is permitted to sign the joint parenting plan placed before the court. Yes.
Much
obliged.
Much obliged.
No representation for dismissal day after tomorrow. Yes. Same order. No representation.
Hearing for petitioner, my lordship, in serial number 48, my lord.
Yes.
Praise for a short accommodation, my lord, that advocate on record is facing some personal inconvenience, my lord.
2017 writ petition.
Matter may be taken up in the next week, my lord.
Post this matter not in final hearing. Post it under part third on Tuesday 16th. Otherwise, this final hearing will be here only. Post this matter as part third on 16th. That matter also, this matter also part third on 16th. Yes. They have not come. Tomorrow? That matter post tomorrow. Yes. Langaus for the petitioner, I sought for a Passover. And even in the, it is only it has come up in the evening.
Yes.
Afternoon.
Yes.
Then counsel for the, petition asked for a Passover. And again requested for adjournment post finally tomorrow. No further adjournments. Yes, any signatures?
Submission, my lord. And serial number 8, there is an interim order, my lords, which need to be extended, my lord. In serial number 8, my lord, there is an interim order, my lord. It has to be extended, my lords. Morning, another council has taken adjournment without our knowledge, my lords. Serial number 8, my lord.
Serial number 8, if there is interim order, extended till the next date of hearing.
It is 27 petitioners.
Yes.
Sorry. Last date of hearing, your lordship is directed to pay the 30,000. I am paying the 30,000, my lordship. The next date of hearing is on 19th, your lordship. You will pay the any balance, my lord.
And counsel for the petitioner handed over an amount of rupees 30,000 in to the respondent before this court. I said respondent.
Yes.
To the respondent before this court. It is submitted that the matter is coming up before the court when?
19th.
On 19th. Post this matter on 25th.
Interim order.
Interim order earlier granted is extended in that.
Please, please.
ಪ್ರಾರ್ಥನೆ
Huh?
question
Anita? He's talking something.
He wants one. So that's why he's asking.
Which year?
Which year? In the petition wants.
Tomorrow. Post tomorrow.
Madam. 27 ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಸೈನ್ ಮಾಡಿಸ್ಬಿಡಿ ಅಮೌಂಟ್ ರಿಸೀಡ್ ಅಂತ. ಆಯ್ತು ಇರ್ತೀವಿ.
serial number 30. Serial number 30.
Serial number.
Serial number 49. 9. And date ಆಗಿದೆ ಏನಂತ.
30 date of 30.
32, madam.
Madam 49. Madam 49, madam. Right, 49. 9. 16, 7.